Yes. Hello, my beautiful friends, and welcome back. What an amazing live stream we have planned tonight. We've got Jack Smith, the man who was prosecuting President Trump for his classified documents, alleged crimes, which were not crimes, with his own classified documents problem. We've got text messages, internal messages between people on Jack Smith's team saying, oops, we left the door to the skiff wide open, and they didn't really know what to do about it. And we have them all published courtesy of Senator Chuck Grassley. So we're excited to get into that and unpack everything that is going on there. Then we'll turn our attention to some election news because we've got some big stories that dropped today. We've got the DOJ sending serious warnings out all across the country to all 50 states saying you better get your act together or else you may face criminal charges coming from the Justice Department themselves. We'll see exactly what Harmeet Dhillon had to say. We've got some panicking out of Arizona. Adrian Vance seems a little bit nervous about this, trying to spread the blame around, saying, I'm not responsible for any of this. Don't look at me. Don't get mad at me. We'll see what he said, and then we'll take a look at an appeal. The DOJ, of course, fighting to get their hands on the lists under federal law that allows them to do that, and took this one up for a demand for a rehearing in the Court of Appeals that is governing the Michigan case with Jocelyn Crazy Eyes Benson. Then we've got a federal judge war that is brewing over election integrity. This is a fun one. You can choose your fighter, whether you want Sparkle Suknanon or another gentleman out of Florida. They are both saying different things. One says you can't use the SAVE database at all. The other is saying you have to use the SAVE database to validate voters. We'll take a look at the arguments because we've got dueling opinions and orders that are going to be directly conflicting with one another. And we'll see what the DOJ does about all of that and some impeachment momentum for the Trinidad judge named Sparkle Suknanon. And so we're excited to have you here. Hopefully the tubes are warming up. I know there was a little bit of a blur out the beginning, but hopefully we're connected all across the fruited plains now and coming in loud and clear. Sometimes there's some cobwebs in those tubes, but looks like we're coming through loud and clear. That's tremendous news. So let's go ahead and get started, shall we? Starting with this case, as soon as the screen reorients itself and we get this figured out over here, let's turn this one. Let me see what I'm doing here. Let's turn this one. I got to fix this. My apologies. Sometimes this kind of dumps out on us. And let's see if this will change. Let's go back over to this one right here. And Eureka, we're back in business. All right, sometimes it errors out as soon as I click live, but it's working. So let's get started. Jack Smith busted. The very prosecutor who said Trump was a classified documents criminal now has a classified documents problem of his own. We know that he was an illegitimate person and not even lawfully appointed to prosecute the case. Not a real boy, as we like to say here. And now he's in big trouble. Chuck Grassley is the person who brought this to our attention, and he put on X, in his usual Chuck Grassley fashion, a little bit of a preview. He says, today I released messages, internal messages that we'll take a look at from Jack Smith's team, showing that Biden DOJ personnel, including people assigned to the special counsel's office for Jack Smith, potentially mishandled classified material while they were prosecuting President Trump for that very offense of classified material mishandling. He says the messages indicate hypocritical and careless behavior, and they merit further investigation, maybe even criminal charges, because you're not allowed to do that. Now, in this case, of course, the president has extra presidential powers, being the sole executive of the nation, to declassify documents. He's got constitutional prerogative to the opinions of his advisors and of his cabinet members in writing. The Constitution talks about this. And Jack Smith's people do not. They are just lowly DOJ employees who were apparently leaving the door to the SCIF, the secured facility, wide open, meaning anybody could come in and I guess access the document. So they're in big trouble. Now, the Senate Judiciary Republicans also fleshed this out a little bit for us. Before we get into the actual document and the messages, you can see them all here. We'll zoom in and we'll learn about the people that we saw prosecuting Trump, including, remember this gal, Molly Gaston, AKA Highlighter Girl, who was very influential in the January 6th case. All of these prosecutors were essentially colluding together to take out a political opponent, and I hope that there is a serious investigation into them, including J.P. Cooney and Thomas Wyndham. But here's what the Judiciary Committee had to say. From the Senate, they say messages that Chuck Grassley got show that Biden DOJ, including people assigned to illegitimate Jack, potentially mishandled classified material, all while Jack was prosecuting Trump. According to the messages, an individual was given access to classified materials without confirming that they had a need to know about these documents. So somebody who didn't lawfully have access got access. Then there was at least one instance in which the potential movement of classified materials that were housed in a DOJ sensitive compartmented information facility, a SCIF, was unaccounted for, documents just popping up out of nowhere. And then there was also, in their own messages, somebody said this is a violation, quote, and an incident. And we need to talk about this when the SCIF that was accessible to Jack Smith's office was left open at least overnight, wide open, and potentially even longer than that. So now Grassley's calling out the hypocrisy on this thing. And we have now got a letter over to the DOJ, Todd Blanche, to say, can you answer a couple of questions for us? Because we'd like to know exactly what went down, and we'll go into all of those questions in just a moment. But Grassley made the official release over on the Judiciary Committee website, coming out of Butler County, Iowa, and he walks us through all of the things that happened, and he gave us this quote right here. Talk about the pot calling the kettle black. According to these messages, Biden DOJ people may have committed the very crime that they were prosecuting Trump for. This is yet another double standard of justice. Remember, while Hillary Clinton and Joe Biden escaped accountability for mishandling their highly classified information, Joe Biden, nothing happened to him. He had documents all over the place, in his office, in his garage, in his residence. And they said, he's just an elderly, well-meaning old man who doesn't know where he is and just likes ice cream. And so he had no idea what he was doing, so no charges. No jury would possibly convict him. Hillary Clinton, same thing. She was even worse. She set up a specific server and she was organizing and orchestrating the transference of classified documents in her private emails in apparently the basement of some building somewhere, setting up the criminality so that she would not show up on government records. And what happened to her? Nothing. James Comey came out and didn't do anything about it. So, of course, Jack Smith and the Biden DOJ, they came out to paint Trump as a felon, and their goal was to ruin him politically. It was a full-blown retribution, full-blown political attack in order to win the election and really to put him in prison. These and other records I've made public show that the Biden DOJ was unquestionably careless, not to mention highly hypocritical. And that's a nice statement, but I would add criminal. No one's above the law, especially not even Jack Smith's team. So here's what the letter says. Now, this went over to Todd Blanche, acting AG, who is coming up for a confirmation hearing pretty soon out of the Senate, sent on July 8th today, fresh out of the oven, saying, all right, AG Blanche, listen, Todd, got some new information for you here. Explaining that messages involving personnel in Jack Smith's office raise serious concerns here about the Biden administration's failure to properly secure classified materials, saying these messages that we're about to read through right here that explain exactly what happened were produced by the DOJ in response to a request for communications from Jack Smith's personnel, everybody inside on his team. Now, the messages show that these failures caused a security violation and incident, quote, where a Justice Department SCIF accessible to these personnel was left open overnight and even potentially longer. For example, the messages that we're about to read show that there were concerns that one, an individual was given access to classified materials without confirming that they had a need to know. They did not meet the standards in order to see these documents. And two, there was at least one incident where the potential movement of classified materials that was accessed by Jack's people was housed in a skiff and it was unaccounted for. Don't know where it came from, don't know where it ended up. Now, and number three, there was also a violation incident where the skiff was left accessible to personnel and they went home for the night and it was left open at least overnight. Now, the messages appear all related to Jack Smith's case against President Trump for mishandling classified materials. And I want some information about this, Todd. And so hopefully Todd sends it over. Todd Blanche. So they started here. They say in subsection A, there were concerns that individuals were provided access to these classified materials without confirming that they had a need to know. Any material housed in a skiff also may have been moved. Here are the messages. These came in between a person called Carly Rodriguez and Julie Edelstein. And they've got their acronyms down here for their names. So Carly's in CVR and Julie is JAE. So Carly sends a message, and we'll keep tabs of the dates here, July 24, 2023. They explain from Carly to Julie. Hey, Julie, thank you for not backing down on this. Need to know issues and access to classified material. It's complex, but I completely see and agree with your points. National security and classified is very diffident or different than usual. Patience for both of us because this may still pan out, ... Sounds like she might say, we have a problem here and we need to make sure we're following the rules because we're not following the rules. And so it is different. This is classified. It's not national security. So we got to tighten this thing up. She says, let me know if I missed anything at the end there. And by the way, I was logging off as someone was asking Ray a question. Julie responds. She says, I give up. I'm not even sure I had the right answer. I just thought it was worthy of discussion. So very frustrated. They're talking about following classified rules. And Julie just says, I give up. I can't even take this crap anymore. No one's following the rules. This whole thing's ridiculous. So then we fast forward a while. July goes all the way to October. Now we pick back up in October. Then Carly sends back to Julie. She says, hey, just picked up a classified letter for the other case. Zero heads up from the CISOs. Classified information security officers. No one let me know this document was here. I just happened to be here. Like she walked in, just picked up this classified letter for the other case. No one told me it was here. I just happened to be here. Where'd it come from? Julie says, ridiculous. Carly says, let me know if you want me to call Jay and talk him through the material in the skiff to get solid numbers. Julie says, thanks. I just tried calling Brett, but he didn't answer. And remember Jay Bratt, one of the other Oompa Loompas who was prosecuting the president back at the time, but he didn't answer. Let's give him a couple minutes. If we don't hear back, it's probably a good idea. So then Carly says, also, love how Dan just moved forward with clearing someone without the need to know confirmation. He just waved this guy through, Dan. She says, quote, I think writing facetiously, were there any concerns, ... Don't care if there were. So she's wild. He just moved this person through without any need to know confirmation at all. Were there any concerns? Don't even care. Wave him on in. She says, just don't want Jay to leave, but also not sure if Brett moved the material or not. Would be best to hear back from him first. Then Julie responds, hey, got him on the phone now. Julie says, Brett doesn't remember. Where these documents come from? No idea. Can you call Jay? Yes. Thanks so much. So Jay Bratt was much higher up and was one of the senior prosecutors on Jack's team. And so they're all kind of asking where this document come from, classified material, call around. Anyone know? No one knows. Other people just came on in, waved in to access classified materials without even following proper procedures, all mishandling the documents straight to jail. Subsection B continues. Now, Grassley writes for us. He says, a skiff accessible to Jack's personnel was left open overnight and potentially even longer. And this created a violation and incident that they commented on, and there was limited help with oversight to even secure the skiff at all. So then once again, we've got messages, same person, Carly. Now she's talking to William O'Neill. William says, hey, I just tried to lock up the skiff, but apparently my PIN isn't working. It got upset with me and now says door in alert. This is weird. April 18th, 2024. Do I need to find someone who had PIN access who can enter their PIN? Little time goes by, about 11 minutes. He says, disregard. I found TPW, somebody else on the team, and he will assist in closing the skiff. I will reach out tomorrow to find out why my PIN doesn't work. Then Carly responds, this is the next day. So he leaves. I will close it on April 18, 2024, 6:31 in the evening. So presumably he's leaving. Then Friday comes around. Carly goes back in. April 19th, 24, elections months away. Who opened the skiff yesterday? She asks. That's usually the go-to for closing if no one's around. Sends another message. Did you get your PIN issue resolved? William says, I drafted the email this morning, got pulled away, but I'm going to send it shortly. William says, no one opened it yesterday because no one closed it the day before. You mean it was open the entire time? She sends a panicked response at 11:12. Well, who opened it the day before? So no one opened it. No one's on the log opening it because it wasn't closed. So if it's not closed, you don't need to open it. Just walk right in there. So that's a violation and incident, she says. Who opened it? That's a violation and incident. I need to know the details. So he says SLV did it, right? More acronyms for someone else. She says, okay, I'll send an email. Also, she says, going forward, if I'm not there, will you please check the skiff before you leave, okay, to ensure it's closed? She goes, oh, crap. Now that Jamie Raskin, presumably, and Brett are gone, and so maybe Jamie was in there, I'm very limited in help with oversight. And William says, yeah, I was planning on doing that going forward. Like I got there, it was wide open. You know, what do I do? That's why I checked last night. I don't want people forgetting. Okay, thanks. Then William says, okay, so SEPS, S-E-P-S, somehow F's up people's access, and they are working on resolving it. It only affected those who had credentials made for them recently. Then Carly responds and says, sheesh, it never ends. And we know who the name of this SLV person is. It's Stephanie Van Buskirk. So she opened it and then maybe didn't close it, which means the whole classified skiff access was left wide open overnight. And Raskin was in and out of the building, it sounds like. So maybe he was in there mucking around. Maybe he's somebody who should also be prosecuted for this. So then in subsection C, Grassley continues, he says, Stephanie Van Buskirk was identified in the messages above as opening the skiff the day before, and that resulted in the violation and incident, and she appeared to be an assistant to Jack Smith. And also we've got Molly Gaston and Thomas Wyndham. And these were two people who were also on Jack Smith's illegitimate team. And Molly, we know here lovingly as Highlighter Girl, because she was the one who was presenting the case to Judge Chutkin, the January 6th case in the DC court. And Molly was saying, hey, I know there's millions and millions of pages, even more, according to Trump's defense, than Walmart versus Visa. Millions of pages of discovery. Walmart versus Visa took like a decade to litigate. But what they were doing with this case with the president was to try to litigate it in like 6 months, even less than that, to get it done before the election so that they could call him a felon and kick him off the ballot, which they did anyways, and then try to steal it from him after they put him in jail. So Molly said, hey, Judge Chutkin, why don't I just highlight everything that they need? And I'll like put tabs in the discovery that's really relevant to them. And then me as the prosecutor will educate the defense about all of the evidence. And then the defense can just go off what I tell them they need. And Judge Chutkin said, perfect. Love that idea. So we'll just go ahead and schedule the trial. The whole thing was ridiculous. So then they are communicating with each other, and Molly, Highlighter Girl, says, is Jack assistantless at the moment? J.P. Cooney, who I think just ran for office, I think he was running in Virginia and he just got redistricted out after the Virginia Supreme Court said, you guys are cheaters. but I'm pretty sure he was running for office again. Is Jack assistantless at the moment? He says kind of, but not totally. Cooney says Stephanie is helping and the whole team is pitching in. Molly says, got it. And then JP says, well, SLV is back today. She is going to see if she can help putting materials together for Jack at the end of the day. Please use her help if it helps you, whatever is easiest. From Molly, Thomas, and JP Cooney. So then Grassley continues. He says, this whole thing. While serving as Secretary of State, Hillary Clinton literally mishandled highly classified material. And what we saw there is that even the server review found 38 individuals culpable for 91 security violations. How many people had their homes raided? 0. How many underwear drawers did the FBI agents go through in Bill Clinton's closet? 0, fortunately for them. But they went through Melania's because, of course, they are partisan political hacks. Hillary got off with a slap on the wrist, still thought that Comey would cover up for her and that she could win. She didn't. She got obliterated and will never be the president. So not only did the Obama DOJ not prosecute, as shown by records that have now since been declassified, but the Obama FBI also failed to fully investigate the necessary leads. Then they turned their attention to Joe Biden, and the Biden DOJ refused to prosecute him. He had decades of mishandling highly classified info, even though the department determined that he had willfully retained and disclosed these materials. Nothing happened because he's a confused, elderly, well-meaning old man. Now, the text messages above show that Jack's people during the Biden administration discussed an individual who was given access to this classified material without confirming their need to know, and they failed to properly secure the SCIF and the information held inside, which actually caused a literal violation and incident. So this conduct appears to show that Biden's DOJ may have mishandled classified information at the same time while they were prosecuting President Trump for the same crimes. This is yet another example of the double standards that have existed in the previous administrations, and they lectured us for years. No one's above the law. So hopefully that standard applies back to them soon. So Grassley saying, hi, Todd, I need your help on this. Will you, first of all, prosecute them? But if not, I need answers to this. Did the SCIF at issue in the messages contain material that was part of Jack Smith's prosecution of then candidate Trump? If it did, we may have a tampering of evidence problem. We may have a chain of custody problem. Think about like if you're getting charged for a DUI and somebody leaves the blood sample open overnight and somebody else could come in and drop a couple drops of alcohol in there and then kind of seal it back up and then put it right back in there. You go, oh man, the whole crime lab's been wide open. Weird. That blood would be disqualified. It would no longer be reliable. All of that evidence would have to go away and the case would be dismissed. So what was inside the SCIF and who touched it? Who added evidence or subtracted evidence that may have exonerated the president? Who perverted the entire basis of the charges? So did the Biden DOJ perform any investigation into Jack Smith once they learned about this? They said it's an incident. They got to report it. What happened after that? Personnel were given access to these documents without confirming they had a right to it. If they did investigate that, what happened? If they did not investigate it, why not? Grassley asks, unauthorized access to or mishandling of classified materials, were they investigated for that? If yes, what happened? If not, why not? If any materials, including classified evidence, were compromised, just as we mentioned, missing, altered, or tampered with, did they even check? Did they just say, oops, close the door? Who was responsible for failing to properly secure the SCIF? We want names. Have they been held accountable? Who was provided with access to the SCIF without a need to know? Who was that person that you shoved in there? And who was responsible for the security violation and incident that we just learned about in the text messages? Any repercussions for them? And by the way, did Jack Smith's lawyers notify Trump's counsel that there may have been a perversion of the chain of custody, that the evidence, the blood vial, may have been tampered with? Did they tell the federal court that there was a violation and incident that pertained directly to potential data and evidence that they were using to prosecute the president? Did any of that get transmitted outside of their office? Yes or no? And please provide the names and positions and duty assignment for all of Jack illegitimate, not a real boy's team, other DOJ people who were granted access to these materials. And we want the names of other people who were also authorized and unauthorized while Jack Smith was conducting this sham prosecution. Thank you for your review and your responses. If you have any questions, please contact our staff. Sincerely, your friend, Chuck Grassley. Over to Todd Blanche. Very good questions. And Jack Smith is seemingly getting nervous about this. He's hitting the media, running around. He was just on with Jon Stewart. And I watched the clip. I'll spare you the pain. But these people are hilarious. They're still ruminating over this. They just can't let it go. They can't realize that all of their prosecutions and all of their caterwauling, of whining and moaning about democracy and trying to steal the outcome and change the reverse, all of it was in one ear and out the other of the American people. We said, yeah, we hear you're crying about this, but we're going to reelect him because it was stolen and we want actual election integrity. Nobody believes Joe Biden won in 2020. The guy was a vegetable back then. And then they propped him up with popsicle sticks and ice cream cones for the remaining 4 years. And we got to see it. And then it was all confirmed after they lied to us for 4 years about it when he walked onto that debate stage and fell right on his face. So question, of course, here, did anybody know about it? And sounds like there's a bunch of criminality happening behind the scenes. They were committing the very crimes that they were accusing the president of. And then they go out and they still whine about this on the media. And Jon Stewart and Jack Smith had an interview and they're just like, wow, democracy's over. Our system is so broken, blah, blah, blah. Meanwhile, turns out they're the ones who are committing the crimes. So this is Jack Smith. He was on a couple days ago on MS Now. He gets asked the question, Jack, are you worried that you're going to get indicted? He says, no, of course not. I don't even think about it. But the answer is obviously a lie. He thinks about it a lot, which is why he's doing the media rounds right now to get ahead of the story. Here's illegitimate Jack, not a real boy, will never be a real boy, and is a total failure based on his inability to do anything that warranted or resulted in any actual convictions as it relates to President Trump. Here is Jack Smith.
I don't want to see people run from public service because of that possibility.
Do you expect to be indicted?
Listen, Donald Trump has made a bunch of statements.
He said he would indict you, yes.
You should be indicted.
Nicole, I honestly do not spend a lot of time thinking about the things he says about me and his
Yes,
threats
you
about
do.
me.
Oh, yes, you do.
I'm real focused on
What?
the people who I work with, looking out for them. I'm real focused on how the Justice Department's going to be better going forward, things like that. In my situation, I did my job the right way.
No, you didn't.
I had an all-star team. I mean, Nicole, the agents on my case, if I were to walk you through all the awards they've won throughout,
Nobody cares about your stupid awards that you hand out at the DOJ. Everybody gets a participation trophy. Every time there's like a birthday, they're like, you get a birthday ribbon. Wow, you're a great prosecutor. Amazing. It's like a bunch of children giving themselves awards, patting themselves on the back for it, and then using those awards as cover to confirm that they're legitimate when everybody knows they're illegitimate. Like, oh, look how credentialed I am. Okay, so you think that is a justification for your incompetence because you guys gave yourselves a bunch of awards? So he seems very nervous, obviously. He is talking about his team as though they're stellar, and they're not. They were the ones who just left the door to the skiff wide open as they're handling a classified documents case.
Generations of administrations, we would be here all night. These were superstars. And I'm much more concerned that those people get to serve in the department, get to serve in the Bureau again someday.
Well, hopefully that never happens. And maybe they'll be indicted for mishandling classified documents. Chuck Grassley just talked about his stellar team. They're all sitting around here saying ridiculous. Classified documents just posted up in the middle of nowhere. No idea where they came from. No idea why certain people are being waved on in here to access the documents. Doors being left wide open. And this goes, I mean, it gets even deeper than this. We know that there were other allegations that classified documents were being mishandled by the FBI team that was also working with them as they were going to coffee shops and things like that. So they're in big trouble. You can see why he's out front and center. He's trying to protect them and trying to seed the narrative that they did nothing wrong and they all got a bunch of participation trophies. So therefore, they're stellar people. We know that they're not. They're partisan political hacks. They rightfully were thrown out of the DOJ. And hopefully justice comes their way because it's their standard. No one's above the law. No excuses for this. Hopefully Todd Blanche heeds this letter from Chuck Grassley, responds to those questions, and adds this into the prosecution roster. And we start to see some justice coming soon for these people. So we're going to keep our eye on this, but it is a nice victory to see that the very people who accuse you of doing something bad are doing the bad things themselves. It's confession through projection. We always knew it. Now it's confirmed in writing. The text messages are there. Jack Smith's team mishandled classified documents, and hopefully justice is coming soon. All right, we've got more to talk about here, but that was a good one. Feels vindicating in many ways. And speaking of election fraud and other fraudsters, here's a good one. And the DOJ is now unleashing. Let's get into this story right now. The DOJ just sent criminal warnings across the entire country saying if you're a secretary in one of these states and you're not complying with law and you knowingly do bad things, we're going to prosecute you. That's what we're here for. And they're flipping out about this all over the country. We've got Adrian Fontes out of Arizona, who's seemingly nervous. He says, I'm not responsible for any of this. I'm following the law. I'm not doing anything bad. It's the county recorders. Go talk to them and leave me out of it. But this is the letter that was sent over to Jocelyn Benson out of Michigan, one of the worst secretaries in the country, who's now running to be the governor out there. She has been the subject of many lawsuits. She was the one who perverted Michigan law back during 2020 and the COVID era. When she got sued, she entered settlement agreements, bypassed the legislature completely, wanted to impose rules that presumed that all signatures were valid without even checking them. And now she's getting a warning on this. And it has been confirmed that this letter went out across the board. Just as a friendly reminder, and Andy Mannix, he shared this. He said the DOJ spokesperson is now confirming this has hit all states. The department, yes, quote, sent these letters to all 50 states and to DC asking for voluntary compliance in a timely manner. And you've got obligations under federal law. You have to make sure only citizens vote in federal elections. And if that doesn't happen, and you enable it, you are knowingly allowing it to happen because you're not taking action to prevent it from happening. We're coming for you. So we'll get into the actual letter, and then we'll also see what the DOJ has done on an appeal. They're taking this one up to the Sixth Circuit as it relates to Jocelyn Benson, saying we have a right to inspect your lists, and we're tired of you pretending we don't. Here's what the letter said with the criminal warning embedded therein. So Jocelyn got this one. She said, all right, Secretary Benson, this letter is sent to you because you're the chief election officer out there in Michigan. And this serves as notice of federal laws that are applicable to elections. We have an obligation to ensure free, fair, and transparent elections. Now, also attached to this letter is a memo titled Federal Requirements for State and Local Officials. This outlines various responsibilities that you have to comply with, or else you will face potential criminal penalties for those who fail to carry out their duties. Now, federal law, as you know, mandates that you properly maintain election records and take certain actions to ensure that only eligible U.S. citizens cast votes. We've got a bunch of civil rights rules. We've got the Voting Rights Act. We've got the National Voter Registration Act. We've got HAVA, the Help America Vote Act. So in addition to all of these authorities, to seek injunctive relief, we can sue you, which we're doing. We're going to go back to that appeal in a moment. But we also have authority to prosecute criminal violations. If you read the law, Section 12B of the NVRA makes it a crime for an election official to knowingly and willfully deprive, defraud, or attempt to defraud residents of a state of a fair and impartially conducted election process. The procurement, casting, or tabulation of ballots that are known to be materially false, fictitious, or fraudulent under the laws under which the election is held will cause a problem for you. One example, if you knowingly retain non-citizens on your state voter registration list one of the lists that we've been suing over for months now. And if you send ballots to the people who are still on that list because you don't want to clean them up, and then you count those ballots, that would constitute a criminal penalty. That would be procurement, casting, and tabulation of ballots that are known to be false in violation of the NVRA, and we're going to indict you for it. So in addition, any individual who knowingly and willfully gives false information in registering to vote and or in actually casting a vote, or anyone who conspires with another to violate this section can be criminally prosecuted, subject to potential fines in accordance with the law. And if you also forgot, we also have 18 U.S. Code section 1015. It says any individual who knowingly commits fraud or knowingly makes a false statement with respect to registration, criminal prosecution, and you shall be fined and imprisoned or both. Now, moreover, while federal law obviously makes it unlawful for non-citizens to vote, state election officers, including the chief election officer, that's you, Jossie, could be criminally prosecuted for aiding and abetting the violation under any one of these laws. 18 U.S. Code 1015F, it's a felony for an alien to say I'm a citizen in order to vote. 18 U.S. Code 911, it's a felony to falsely and willfully have an alien represent himself to be a citizen. Or Section 611, unlawful for an alien to vote in a federal election. And so, very simply, in conclusion, any election officer, that's you, including the chief election officer of the state who knowingly retains non-citizens on the state's SVRL, the voter list, or facilitates non-citizens in actually receiving or casting a ballot, you could be subject to criminal liability. And this is exactly right. They should be prosecuted for enabling non-citizens to vote because they don't want to check the list. An intentional act that is aimed at diluting our votes of citizens could constitute a violation of the law. And 18 U.S. Code 241 makes it unlawful for two or more persons to conspire to deprive us of our constitutional rights. And so we encourage you to contact us to discuss what next steps you should take to maintain clean voter lists as required by law. And let's not forget, Judicial Watch is suing Shirley Weber, the Secretary of State in California, for hundreds of thousands of ghost voters that are still on their rolls because Shirley refuses to remove anybody off the list in various counties, not making various counties actually follow the rules. And so all of this got sent out by Harmeet Dhillon, Civil Rights Division. She says, "We would like to assist you. We want to help. Please respond to this letter letting us know whether you're going to comply with these rules or not. And if you don't, then we can just say essentially you're complicit in enabling this type of criminality. Please send your written response within 5 days to us at this email address. Sincerely, regards, your friend Harmeet Dhillon." So that went out to Jocelyn Benson, and we have reaction on this from Harmeet herself. She says, "We are proud to safeguard every American's right to vote, and we will continue routine nonpartisan election monitoring." We saw yesterday the confirmation that they were sending monitors to 3 locations in Michigan. Now it is being expanded, much as we suspected. We want to do the same thing that Joe Biden did. Monitor the elections to equally enforce the law. Stay tuned for more. Here's Harmeet Dhillon explaining what is going down from the Civil Rights Office at the DOJ.
In 2026, in this upcoming primary season, the United States Department of Justice Civil Rights Division, as it has done for decades, is this year sending election monitors into 15 different jurisdictions in 6 states. And those states are Arizona, Michigan, Massachusetts, Minnesota, New Hampshire, and Virginia. And we're sending the monitors into cities and counties where there may have been some problems in the recent elections. And so this is something that DOJ does routinely. So for example, in 2022, in the primary season, there were 9 jurisdictions in which the prior administration sent election monitors during the primaries. In 2024, similarly, there were, in that election, 27 different jurisdictions monitored by the Department of Justice Civil Rights Division. So this year, we're kind of in the middle of that with our 15. And what we hope to do here is increase voter confidence, make sure there are no language barriers or access to voting for Americans with disabilities, or sort of failure to make sure that the polling places are open correctly for the amount of time necessary, and that everyone has appropriate access to vote who should be allowed to vote. So this is an important goal that increases voter confidence. And it's also important to make sure that our voting is accurate so that every citizen who votes has their vote counted equally without being canceled
makes
out by
sense.
somebody who shouldn't be voting. Now, unfortunately, in taking Michigan as an example, we've gotten some attacks from leaders over there, the Attorney General and the governor. They don't like the fact that we're doing this, but to be clear, both Republican and Democrat administrations have sent monitors to Michigan and these other jurisdictions in the past. I think it's a great exercise of our oversight duty and our enforcement duty to enforce the Help America Vote Act, the National Voter Registration Act, the Voting Rights Act, a very important statute, and other civil rights statutes like the Civil Rights Act of 1960. So I'm proud to be helping organize this effort and send those monitors to help increase all citizens' confidence in the outcome of our elections. And stay tuned as we get towards the general election, where there'll be an even more expanded program for vote monitors, as DOJ has done for decades in our great nation. Thank you.
Thank you, Harmeet. We appreciate that. And this has some individuals very nervous. So turning to Arizona before we go back to Michigan, Adrian Fontes is not liking this update. He issued a press release saying, we already are doing this. We have strong checks and balances, and you sending us a letter threatening criminal prosecution is inappropriate. He says we've got strong rules. We already verify everybody, and the suggestion that we're failing to do our job is not supported by the facts. We work every day to maintain our lists, which will be great. If their lists are maintained, then there will be no problems. It's insulting, he says, to insinuate that good people at our offices, our county recorder's office, he's not a county recorder, he's a secretary of state, are not doing their jobs. You see how it's kind of deferring responsibility onto them? They're everyday Arizonans. They spend their time making sure our elections are accurate and run smoothly. It's no exaggeration to say that they're the backbone of American democracy, so on and so forth, and we shouldn't have political rhetoric or intimidation. Now, that's in his written statement, but then he seems a little bit nervous. He went out to Rock Springs Cafe in Arizona, which is a great place. They have the best pies, I think, in the state, and you can just pop off there on the I-17 and load up on some deliciousness if you'd like, and so maybe that's what he's doing here, stopping to get some pie because he's so nervous he has to get some comfort food. But he said, you at the DOJ should be working with states to ensure elections are run securely and smoothly. We're thinking, where the hell have you been here, Adrian? They've been trying to access the lists. They've been trying to get the save database implemented so that you could check against the list. Your party and you have opposed it at every step of the way. They've already been trying to securely and safely, smoothly run elections. You've been stalling it out from the very beginning. But listen to him in this video because he sounds very nervous. He's saying, it's not my responsibility. I don't do anything. I'm already trying to be cooperative, so don't get mad at me. Don't prosecute me when you find that there are illegal aliens all over our lists.
Hey, folks, here we go again. Harmeet, Dhillon over at the DOJ send me a nasty gram threatening criminal prosecution for aiding and abetting folks who aren't eligible to be on the voter rolls. Here's the problem. The data doesn't belong to the Secretary of State. The registrars of voters in our bottom-up state are the county recorders.
I can't check the list. So don't put me in jail. It's not my list, it's their lists. And there's nothing I can do about this.
Arizona. And I'll tell you what, Department of Justice, you shouldn't be threatening people with criminal prosecution. Maybe help us.
You guys, you jerk, threatened a bunch of the county recorders. You and Chris Mays sent a letter out to the Arizona county recorders and you said, do not give the FBI any information. The FBI sent in a valid subpoena for lists and the Arizona Senate president sent over information to them. Then they sent out a warning to all of the county recorders and they said, if you respond to any federal subpoenas, you may be committing crimes. You may be committing felonies because you're violating privacy laws in Arizona. So he is now upset that he's on the receiving end of this when he was the very guy, along with Chris Mays, the AG, who was sending threats all across Arizona to the county recorders. And he may not have the data, but he coordinates across the board and he sets the standards, and they would have to report the list maintenance back to him. And so him sitting here pretending that he's got no role in this, so don't put me in jail. I don't maintain anything here. I'm innocent. Nobody believes that, which is why he's going to get pies and make a little video.
Out. Maybe get us the cybersecurity we need or the federal funding we need to make sure to do
Do you support the SAVE Act? Is that what you are now saying right here, Adrian?
the things that we've been doing for years, which is updating and maintaining our voter rolls to the best of our ability, given
to the best of their ability, which is not good. They have no ability at all. All right, we'll play this out.
resources that we have. That's what's really important here. And just like I referred 28 cases to the Attorney General for criminal prosecution in January, we're going to continue to do everything we can with the resources we have to update and maintain our voter rolls here in Arizona so that we can comply with the law that says only eligible citizens can vote. We've been doing documented proof of citizenship here in Arizona for over 20 years, and it's not an easy thing to do, but we've been doing it well. And I will stand behind every one of our county recorders and all of our county elections officials if the Department of Justice decides that they want to go the wrong way and be enemies to the folks who are actually running our elections instead of being partners for the benefit of Arizona's voters.
Okay, so there was like 3 different disclaimers in there. I, first of all, don't have a list. It's not my list, it's the county recorders. We're also trying to comply with the law, but we don't have the money and the resources to do it. And so if you want to blame anybody, go blame the county recorders. Don't get mad at me. I had nothing to do with it. And we're already trying our very best to comply. So if you come and look at our list, I've already referred people to criminal prosecution. Who knows what happened to those cases with Chris Mays' office. But don't put me in jail, because this dude knows that if you look behind the curtain, it's a dumpster and a disaster, which is why he just had to make this video, taking zero responsibility for it, saying, cooperate with us. We've been trying to do that here, buddy boy. And you guys don't want to cooperate at all. Why don't you just comport with the DOJ and say, here's our list, and then we can validate it and immunize you to say, okay, we checked it too. We didn't find anything. You're all good. If it is so good, we'll help you get there, but they don't want to do it. And so this feels very, very panicky to me, and rightfully so, because they know they're about to get caught with their hand in the cookie jar and time is up. So what is happening now is we're having the same fight over in Michigan, and the DOJ just submitted this one to take it up to the 6th Circuit Court of Appeals. And this again articulates the law is very clear, but all these lower court judges don't want to comply with it because they are essentially on the side of the leftists who are suing. So this is an appeal between Jocelyn Benson, the League of Women Voters, one of these voting groups that's represented by Mark Elias and those guys, Michigan Alliance for Retired Americans. These are nonprofits that are set up literally to file election lawsuits, lawfare perverting our elections. And they sued in Michigan before, and they settled with Jocelyn Benson before to change the election rules using COVID as an excuse, and hack judges just said, perfect, your settlement is accepted. We're going to change the election, even though the legislature didn't say that they could, and they mailed out a bunch of ballots in 2020 against literal state law because of a settlement agreement, friendly on friendly lawsuits. So now the DOJ is appealing this. They've already lost the initial appeal, so they're asking for a rehearing en banc to get the full panel of the 6th Circuit. And they are once again explaining the law is flat on its face, unequivocal. I'll share it here again so that we can confirm it, but they are quoting the Purcell case out of the Supreme Court from 2006. We hear a lot about the Purcell principle, about how federal courts should not be interfering in elections at the final minute. But a key quote from that case is, confidence in the integrity of our elections is essential to a functioning democracy, saying the United States brought this suit to protect that confidence and to compel the lion scamming Jocelyn Benson to produce an unredacted electronic copy of its state voter list. We've got authority to do this under the Civil Rights Act, under the National Voter Registration Act, and under the Help America Vote Act, HAVA, NVRA, and the CRA. They walk us through the law. To be clear, Section 301 requires Jocelyn and Adrian Fontes and Jenna Griswold and Bellows from Maine, all of them requires every election officer to retain and preserve all records and papers which come into your possession relating to any requirement to vote in a federal election. It is a requirement. You have to retain and preserve. But Rob, that doesn't mean that they have to turn it over. Okay. Michigan's voter list fits plainly within the scope of this law. Then we continue on. So based on that requirement, AG Bondi, through the DOJ, sent a demand to Secretary Jocelyn Benson, the presumption of validity secretary, to produce your list. And again, under Section 303 of Title III, quote, the law, upon demand in writing by the AG, Bondi, Todd, or Harmeet, the custodian of any such record or paper must make available the same available for inspection, reproduction, and copying. 52 U.S. Code 20703. You shall retain it, and upon demand that we give an explanation as to why we need it, you must make it available so that we can see it. You're sending people into federal office. Quote, this demand shall contain a statement as the basis. We did it. We explained why we needed it. But then Jocelyn Benson refused the demand. So did Adrian Fontes. So did Chris Mays. So did Jenna Griswold. So did Shirley Weber. So did all the other blue states. And so the DOJ sued. Now, the lower level courts dismissed the complaint. The U.S. appealed. You ordered expedited briefing. You had a divided panel. We lost. But in the dismissal, there were two conclusions that we think warrants an en banc consideration to go back up. First, the majority panel held that the SVRL is not a record, so it just doesn't fall in and under those provisions. It is, quote, internally generated, and it's not a record acquired from an outside source. In other words, they said, we made it, the voters didn't make it, and so you're not entitled to it. Now, second, the panel also held that the DOJ's demand to Michigan was inadequate because they did not like the basis and the purpose. They said it was spread out over multiple letters. And according to the majority, it needs to be in a single letter, even though the law says that nowhere. So both of these conclusions were wrong. They present legal issues of exceptional importance, and we're taking this back up. And if allowed to stand, this decision will paralyze the United States' ability to ensure enforcement and compliance with federal law. You have to maintain your list. The U.S. has a compelling interest to ensure the integrity of our elections. These are national interests. States are sending people into the federal government, and the importance of these tools cannot be overstated. The Congress passed these rules, 3 different separate laws, the CRA, NVRA, and HAVA. The post-election system of judicial review is incapable of testing allegations. And how many times have we talked about this? Once the election is over, you can't do anything about it. In fact, before the election even occurs, you can hardly do anything about it. You sue before it happens, they say, oh, you don't have standing. You're the wrong party to sue. You sue too soon. Oh, your claim is not ripe. It's dismissed on ripeness. Come back when there's been an actual injury. You sue after the fact, then the judges all have tremendous pressure to not overrule the will of the people, and so they don't do anything after the election is over, or they say, sorry, you are stopped from being able to challenge this. You should have sued before. Then, as we've seen in other cases, if the litigation goes on and on and on and on, like is happening in Fulton County, then you get a judge who says, oh, the election's too old. It's 2020. Those crimes are too old. The statute of limitations has expired. So there's nothing you can do about the fraud. And the courts all just find whatever excuse they want to pull out of their butts to make it happen. So now Congress said we have these tools. We can address voter suppression. We can address fraud. We can address systemic maladministration before it all happens. And because the panel opinion is the first appellate decision on this topic about whether the Civil Rights Act reaches to SVRLs, the state lists, there are 20 other cases pending all across the country on this very matter. And the DOJ has been losing these across the board, across the country at the base level. They're saying this is the first one that we're actually appealing here. And what you decide, the full panel of the Court of Appeals will become the principal appellate authority. And so as it stands, the panel opinion provides federal courts with other precedent and we'll launch off there. So we now ask for a full panel decision. Question, did you err? Is the SVRL, you said it was not a record that's in the election officer's possession. It clearly is. Your excuse as to why it doesn't count is because they internally generated it versus receiving information from a voter. Is that actually a legitimate basis? And second, because you didn't like the fact that we sent multiple letters, you want it all to be in one, we can restart this and just send a full letter. So background here on this, we'll hit the highlights of this. It's a big appeal, but this case arose after Benson and Griswold and Fontes and all of them said, you can't access any of this. The DOJ sent letters back in 25 saying we want a copy of your voter list to make sure. DOJ was denied. Michigan refused this, and then they sued. In a published opinion, then the Court of Appeals said, yep, the dismissal is perfect, saying that it's not an actual record, but judges dissented. One guy, Judge Nalbandian, he dissented. He said, you know, your decision here is ridiculous. The majority in the original panel was on a hunt for a non-existent external source limitation. They were trying to say, well, it only meant these records. Does it say it in there? No, it doesn't. The law actually says come into possession. That's it. It doesn't say come into possession from external sources. You have a record. There's nothing that limits what is available based on its origin source. He wrote, Title III covers at least the same government-generated records and the voter files, even if it comes into possession internally or externally. Benson did not herself create this, and since she didn't create it herself, it is an external record as it relates to her. And Title III looks to officers who came into possession of it. Jocelyn, for her, it was an external record. She didn't write it herself. Second, the judge who dissented also explained that the majority was straining, bending themselves to bifurcate the letters to say, well, common sense dictates that the letters should be read together, but they twisted themselves to say it wasn't one complete request, it wasn't one complete demand, and so therefore it's not falling within the scope of the law. So they say, you should hear this whole thing, this is ridiculous. We know the act has a sweeping obligation for the secretaries to provide and retain all records. No one disputes that this is a record, and no one disputes that it relates to the law. The dispute only boils down to what comes into possession of. Did it come into possession internally or externally? But just look it up in the dictionary. Look it up into Webster's. When officers within Benson's office aggregate all the individual voter records into the master list, they get or acquire a new document. The new document comes into their possession. The law covers it. And you're twisting of the rule to exclude internally generated documents. And by the way, many other courts have also found in a similar fashion. Okay, they're not that bright, these federal judges. They like to think they are. Oh, I went to Harvard. No one cares. You can't even read English. So take your Harvard degree and cram it somewhere. You can't even understand the plain operation of the law, which is why you have to twist yourself in order to create your political outcomes. And you say, well, it's a limitation on internally generated documents, but that cannot withstand scrutiny. The panel majority's interpretation adds a limitation into the text that is not in there. Nothing is written into the words. This added limitation says come into, and the majority latched onto that and tried to expand upon it to come to the outcome that they wanted to. What it means, any document that comes in there is available. Jocelyn didn't write it. It's not her work product. And as the judge explained, the historical context also makes clear. Civil Rights Act was aimed at covering even government-generated records coming back out of the Jim Crow South and more. So he pointed out, did a very explicit unpacking of how language works since the majority can't read. Finally, the majority ignored that even under its own reading came into Jocelyn's possession when she received it. It came from someone else, and she came into possession of it. So as long as one officer comes into possession of the list, it satisfies the law, and there is no conflict with any other provisions. Similarly saying the majority was failing to grapple with the words alter in Title III. Then they're saying, well, other statutes protect the privacy rights. And so it's in direct conflict with those other statutes. And this is the point of the law. You can really just search through it and find whatever justifies your engineered outcome. You could even ask John Roberts about that with the birthright case. So if you don't give us the records, you're going to create an environment that leads to absurd results. The state list is not just any record. It is a federally mandated record. We say you have to maintain these things for federal office. And so since the majority was so boneheaded, you need to review this and reverse yourselves. And the Fifth Circuit also held, right after the CRA was enacted, that the sufficiency of the AG's demand is virtually unreviewable. The judge is not the attorney general. The judge does not get to substitute their judgment for the AG's need for the list. Otherwise, they should just become the AG. Here, all we need is a simple statement. The attorney general is following the law, and that's what has happened here. So in sum, we're following all of the rules, and you should consider our demand to be legitimate. Jocelyn Benson is not complying with any of this. And so for the foregoing reasons, you should rehear this appeal, give us the list, and then you won't have to worry about criminal liability. Signed here by David Goldman over at the Civil Rights Division for the DOJ. And again, Adrian Fontes, if he's so nervous about his list having problems on it and him being liable for those problems, why doesn't he pick up the phone, call Chris Mays, the Arizona Attorney General, and say, drop your challenges to the DOJ's demand for the records? Give them the list. They'll check it. And if there's problems, they'll send it back down and you can fix it. Otherwise, how could they hold you responsible for something that they investigated, that you gave to them? And if they find there's nothing wrong there, and you find there's nothing wrong there, you're covered. They're essentially immunizing you. But they don't want to do that because they know these lists are everything, which is why they're fighting tooth and nail and why guys like Mark Elias, the Democrat election super lawyer, is creating and facilitating lawsuits brought by the League of Women Voters and the Alliance for Retired Americans, all of these groups who are waging war on behalf of Democrats. They're not worried about women voters. Women know how to vote. It's not complicated unless they're illegal alien women voters, which would be illegal. So lawsuit now being appealed. We're happy to see that one happening. And Harmeet was also on with Glenn Beck. And this was a new one that just dropped. And she said, you know, it's about knowingly committing some sort of election fraud, knowingly not preventing illegal aliens from voting. You're being complicit in it. You're actually conspiring in some way by being negligent. You're not wanting to take active roles in preventing this crime from happening, which means you're complicit in the crime. Here's more Harmeet explaining how this all works and why Adrian is so nervous.
Knowingly refuses to remove non-citizens from the voter rolls. That's illegal. That is a crime under our laws. And someone who does that and conspires to do that can be prosecuted. So I'm simply informing top election officials around the country, and it includes Puerto Rico and Virgin Islands, that this is their duty. Now, a third of the states have voluntarily complied with us, and we thank them for their cooperation. And in that effort, we have found hundreds of thousands of dead people on voter rolls, and we have found tens of thousands of names of suspected non-citizens that we are now digging into through our immigration files to see whether they're appropriately on the rolls or not. In recent weeks, months, and even the last year and a half, we prosecuted numerous people at the Department of Justice for voting while not citizens of the United States. And it's indisputable, based on evidence that I've seen, that there are tens of thousands of non-citizens at a minimum on the voter rolls in just the ones that we've examined. And keep in mind, 2/3 of the states are fighting us in getting access to their up-to-date voter rolls, but we're using
And it's mostly the blue states who are fighting it. It's California, it's Michigan, it's Arizona. So those tens of thousands will go into hundreds of thousands without any doubt once those lists are turned over.
Other means to look at some of these. And so I think that's very concerning, Glenn. Your vote and my vote is very important and precious to us. And even if one or two people are canceling out our votes, that's a problem for me.
Huge
that's
problem.
a problem for you as a citizen, and it's a problem for the United States. So I think it's very important that people know this. And the other thing is, what we've learned is that many of legal residents of the United States, green card holders, for example, are not aware that they're not entitled to vote in our elections. So, this is educational as well. It's the duty of the states to not register those people and to inform them. And they're not doing that. I can tell you as a 25-year California resident, you just check a box to say you're a citizen. What if you don't speak English that well, or you don't understand the distinction between citizenship and that green card you have that is a legal status? You'd be checking that box, and indeed thousands of people do that. And then they vote, and then they're, making themselves criminals and also subject to deportation. We don't want that for law-abiding people. So I think this is simply good hygiene of our voter rolls, and I think it is unfortunately necessary that we remind people of their duties. I know they're clutching their pearls, they're really upset, but if they're following the law, they have nothing to worry about.
Right. They don't have anything to worry about, but you know what? They're not following the law. That's why they're very worried. That's why Adrian Fontes is out here making videos outside of pie shops saying, I don't actually do anything here. I'm just here for the pie. I have no power. It's all county recorders, and give me more money so I can shove my face. But JD Vance was also out today. He said, what's so interesting about this? Why do the Democrats not want to fix these problems? Even if they don't think it's a problem, why do they not want to just reform the system so that our half of the country stops moaning about it? It's because they know it's a problem and they're exploiting it for their gain. Here's JD Vance explaining how that works exactly.
There's, of course, this big debate about how much election fraud happens in the United States of America. You guys know my views. We're not going to settle this here. First of all, any election fraud is too much election fraud in the world's greatest and oldest constitutional republic.
Right.
And number two, if Democrats want us to stop talking about election fraud, I make them a simple deal. Pass the Save America Act and get voter ID, and we'll stop talking about election fraud.
Easy.
We are the only advanced democracy anywhere in the entire world that doesn't require you to show a voter ID to vote. It's simple. Just give us election integrity laws, give us voter ID, and then we will have the confidence to say to the American people there's no cheating. But when they say, number one, we don't want voter ID, and number two, there's not that much cheating in our elections, it's natural for all of us to say not much cheating is still way too much cheating, so stop it and give the American people voter ID. Thank you.
Yeah, exactly right. And they move the goalposts all the time. There is no cheating. There is no fraud. Okay, there's a little bit of fraud, but it's not widespread. Okay, it is widespread fraud, but it didn't change the outcome of the election. And it just keeps getting moved and moved and moved. No illegal aliens are on the voter rolls. Oh, there are. No illegal aliens are voting. Oh, they are. And so on and so forth. And the more you look into it, the more you find, which is why they do not want you looking into it at all. You take a look at the ballots that were seized in Fulton County. Meltdown, 5-alarm fire for the Democratic Party. They sent their best lawyers down there to stop it from happening. And they're still working on that when a new judge just blocked a subpoena that was investigating the actual poll workers who processed those election ballots. So it's a constant fight for them because this is how they win. They have to shift the mechanics of the elections. They have to imprison their political opponents. They have to censor anybody who does not comport with their ideology. If that doesn't work, they try to kick you off the ballot. They have to get reversed by the Supreme Court in order to be slapped down. And then if you just say there's federal laws that say we can just take a look at your lists all across the country, meltdown. Cannot allow that to happen because they're cheaters. They know they're cheaters. They know we know they're cheaters. They don't care if we know, as long as they can continue to cheat. But fortunately, we've got Harmeet. We've got a new administration that is working hard to stop this from happening. So we'll keep our eye on this one. and watch whether the states comply or whether people get charged with crimes for facilitating and conspiring to commit fraud. Thank you for subscribing and joining as we do. All right, we got one more good update here today, and then we'll hear from you. And this one is a pretty fun one. Federal judges now going to war with one another over the SAVE database. We know that Trump issued an executive order that said we're going to start checking the validity of voters. We're going to create citizenship lists, then give those lists to the states. We already have a bunch of this data inside Homeland, inside Social Security, and we learned that a foreign-born dual citizen judge called Sparkle Suknanan blocked Trump's executive order. We covered her decisions some time ago, but the problem was another judge in Florida ordered the agency to restore the SAVE database, the very database that Sparkle obliterated. A Florida judge reinstated, and these two submitted dueling orders back to back. The first one came out July 7th out of Florida, and then Sparkle responded to this today out of DC. And so as we get into it, you can choose your fighter. Here we've got Sparkle Suknanan, born from Trinidad and Tobago. According to her Senate questionnaire, she's a dual citizen, got here like 10 years ago or whenever, then turns around and says, let me tell you how to run your country. I just became a citizen, but I know more about the Constitution than you do. And I don't want to have any people checked when they go vote in our elections. Really, our elections. She just got here. So she, of course, was appointed by Joe Biden. Joe Biden appointed a bunch of foreign-born people in order to obliterate our judiciary and wreck the country. But that's on the blue team in the blue shorts. Joining us from Florida is the red team, T. Kent Wetherell II, a bona fide American appointed by President Trump and born right here in America. Wow. In Daytona Beach, Florida. Incredible. And he says that, you know what? We can use the SAVE database. We can check citizens who are voting in our elections. Weird. So these two have been duking it out, and we've got the orders that dropped, and the New York Times is saying the Florida judge is now ordering the restoration of the citizenship data and the state's ability to actually access it. And they walk us through some of the background here, but there was a new 10-page order out of the Northern District of Florida. Trump appointee came down and issued it, and Sparkle just responded today. Sparkle, who they always leave this out, she's from Trinidad and Tobago, and according to her, she's still a dual citizen, as far as we know. I've not seen any disclaimer of that. She confirmed it in her Senate questionnaire. She says, you're going to disenfranchise people and you're going to be violating privacy rights. And so nobody gets to use the SAVE Act across the entire country, or the SAVE database, not the act, the database across the entire country. And so the back and forth went down. Here is what the American-born judge had to say about it. He said, all right, here's the order. This was the state of Florida suing DHS, and when the lawsuit originated, they were suing the Biden DHS. The case is before the court. Now, it's based on the plaintiff's emergency motion to enforce the settlement agreement. So Florida says, hey, we settled with Joe Biden. We sued them a while ago. We entered a settlement agreement, and as part of that agreement, they said that we could actually use the database to check and validate citizenship. The judge says, upon consideration of this motion from our friends in Florida, shout out to them, by the way, the declaration submitted by the Floridians and the defendant's response from Homeland and its attachment and the amicus brief, once again, the League of Women Voters, it's like a cancerous organization, the same organization that is literally suing in DC. Okay, so this is the Sparkle case from Trinidad. She is handling the case of the League voters who then submitted a brief. The court finds that the Florida motion and an emergency motion to enforce the agreement to use the database is now granted. Amazing. Thank you, American-born judge named Trent. We appreciate you on this one. I mean, T. Kent, not Trent. We appreciate T. Kent in the house. Man, this American as it gets. So he said, the state of Florida, and this is an important date, so put a pin in this, October 2024. Okay, Florida sued October 24 before the election happens. So it's the first in time lawsuit. Sparkle's going to make a big deal about this, and she's going to say, well, you entered into the settlement agreement after the League of Women Voters already sued. And so your settlement agreement should have incorporated their claims, and it didn't. So she's invalidating this order, and he's invalidating her order, which is just beautiful. He says, okay, they sued first. The operative amended complaint sought declaratory and injunctive relief regarding the use of the SAVE system. It's called the Systematic Alien Verification for Entitlements Program, saying Homeland has a law. They have to follow it. The Biden people are not following it, so Florida sued. The goal is to verify individual immigration status if a state requests to do so that you can see whether or not you should give them actual benefits. Most pertinent to the issue that was framed by Florida, the new complaint says that the SAVE system was an inadequate tool to verify immigration status because it required a unique immigration identifier to even search it. So Florida says this whole system needs to be created, but we can't even search for anything. We can't simply search by social security number, by driver's license number, or any other similar identifier. And so we can't actually use it. It's not functional. So they sue. The case was then resolved by a settlement agreement executed by the parties in November 25. So Trump comes in, power shifts from the traitorous Mayorkas' homeland back over into Kristi Noem and now Mullen's homeland. And they say, that's a great point. All right. You do need to be able to search by these things. You're a state. You don't even have immigration identifier numbers for the most part. You have all these other numbers. And so, yeah, now we'll let you search by these numbers. The agreement, writes T. Kent from America, required the parties to cooperate on improving and modernizing the SAVE system, requiring Homeland to ensure that the system actually had the capability to integrate with the Social Security Administration, to allow searches for full social numbers to be used as non-Homeland enumerators, right? So you can actually use it. Also, they needed to integrate with the Social Security Administration to just search by the last 4 digits, and also to enable a bulk upload so that when you are searching for big swaths of people, you can just upload an entire spreadsheet. It spits out the results. So then on December 1st, 2025, the court entered an order dismissing this case. Florida sues, they come to a settlement agreement. We're done. We don't need an active lawsuit anymore. Let's dismiss it. The dismissal order expressly approved the settlement agreement and incorporated it into my order. The judge is saying, I did this. I issued this. And in the dismissal, the court retained jurisdiction for 20 years. So if Homeland starts to fall out of compliance and say, actually, you can't search by social anymore, the judge says, that's too damn bad. You guys entered into an agreement. This is the rule. So then from December 2025 to June, the Homeland people actually performed their obligations. They were following the agreement and allowing the searches. Most pertinent to the issues here, they ensured that the SAVE system actually had bulk upload and a social search function. Then on June 23rd, after the Trinidad judge called Sparkle came down on this, Homeland then disabled some of the functionality, the bulk upload functionality and the social security functionality of the SAVE system after the Trinidad judge in DC called Sparkle Soupnanon entered an order saying all of those systems are invalid and you have to turn it off everywhere. Okay. And she's a DC judge. So she canceled the system for the entire country because she's the president now. That's in the case that he references here, League of Women Voters. So her order came after his order. He says, most pertinent to the issues here framed by now Florida. Florida says, Judge, we're getting our settlement agreement completely violated. Sparky up there in DC said we can't use this. Suki's order, writes the judge, concluded that the modifications to the SAFE system, she says, violated the Social Security Act and the Privacy Act. She just got here from Tobago and says, I know everything about your law now. On June 30th, then, Florida filed a motion to enforce the actual agreement. There were also declarations from a bunch of other states like Florida, Iowa, Ohio, saying, we're being harmed by this. We are suffering as a result of Sparky's order. We no longer have the ability to use the actual SAFE system, and we need it. That harm included Iowa's inability to comply with state law. State law in their state requires verification of citizenship of professional license applicants. Florida and Ohio also have state laws to verify citizenship for votes. So the judge says the motion was briefed on an expedited basis. This judge is stepping all over my settlement agreement. The parties did not request a hearing. The court sees no need for one. There are no facts even in dispute. The briefing adequately frames the issues. We know what the problem is, and time is of the essence in this. And so now the motion is ripe for ruling. I'm not wasting my time. T. Kent in the House. He says this court has jurisdiction to hear this thing. The settlement agreement came out of our court, and we explicitly said in the settlement agreement, I'm reserving this for a period of 20 years to enforce this to make sure it happens. Now, the court did not overlook the argument that the court does not have jurisdiction to enforce this because the Court of Federal Claims has contract jurisdiction. But he says that argument is frivolous. The settlement agreement is more than a contract. This court approved it and incorporated it into the dismissal order, meaning the settlement agreement is not a contract. It's the functional equivalent of a consent decree. So a breach of this is a violation of a court order, which Sparky just ordered, which the court unquestionably has jurisdiction to address. So I am now going to contain this case and maintain it. Now, defendants are plainly now Homeland. The judge is now screaming at Homeland in violation of the settlement agreement. It is undisputed that they disabled the bulk upload and the social search features that are all expressly required in the settlement. The fact that they disabled those features to comply with Suki's order does not change the fact that they violated the agreement. Judge is not happy. He says, she can say whatever she wants, but you still turned it off. And I don't really give a crap about what she says. This is my court. This is my settlement. He says the court now did not overlook the amici's argument that the defendants are not in violation of the settlement agreement. Homeland says, don't blame us, man. Suki up there in DC, she ordered the modifications. She said the whole thing was unlawful. And the agreement stated, nothing contained in this agreement shall impose any duty which would be inconsistent with federal law that's in effect. But he says that's federal law. Now, the problem with that argument to say you're not responsible for turning this off is that the court implicitly found that the modifications were not inconsistent with federal law when it approved the settlement agreement. He says, wait a minute. You think that I would be so careless as to enter a consent decree, as to enter a settlement agreement that is in violation of the Social Security Act, in violation of the Privacy Act? I would never allow you to enter an agreement that is in breach of federal law. So when I entered the order, I already did this due diligence. Now some other judge is stepping on it. He says the fact that another district judge from Trinidad subsequently concluded otherwise does not somehow undo that determination. She just got here. I already decided this was lawful. Now she says it's not. I don't really care. So the court also did not overlook the request to defer this motion until Sparkle in DC, or if necessary, the Court of Appeals in DC rules on their request to stay this order pending appeal. And she just denied that today. She said, I'm not staying any of this. Keep the system turned off. My Trinidad expertise knows that I'm more right than this judge. So the court sees no reason to do that. I'm not deferring anything. There is no guarantee that a stay will be granted. It wasn't. He wrote this on the 7th. Sparky just came out today. And plaintiffs have submitted from Florida unrebutted evidence showing that they are suffering right now real and concrete harm every day that passes without the actual functional SAFE system. And moreover, the principles of comity that might otherwise weigh in favor of deferring consideration until after Sparkle and the DC Circuit does something here are not entitled to much weight, because if Sparkle had deferred to us and our implicit determination that the modifications to the system were lawful, then we would not be in the current predicament. Damn. So Sparkle's overstepping her bounds. She could have deferred to us. Why are we deferring to her? We're not going to do it. T. Kent in the House. Now, they say, admittedly, the court did not undertake an extensive assessment of the legality of the features that require the SAFE system to include when it approved the agreement, but it would not have approved the agreement if it had any concerns that those features are unlawful. And now, having reviewed Suki's order and the counter arguments in the defendant's response and their briefings, he says, I read her entire case. This court makes explicit what was implicit in the approval of the agreement. The modifications to the SAFE system, including the bulk upload and the Social Security search features, do not violate the Social Security Act. They do not violate the Privacy Act. Sparkle and her decision are terrible. She's an idiot. So she should have deferred to us. Our case came in first, and I already did this analysis, and I read all the arguments that she read, and she's an idiot. So this court understands that this puts Homeland now in a bind. They are subject to two contradictory orders, one from this court requiring them to include certain features in the SAFE system, and one from Sparkle prohibiting them from doing so. One of the orders has to give either us or them, and not surprisingly, this court is not persuaded by the arguments that its order is the one that should give. We're not giving up our settlement agreement. So Sparkle better do it. Narrator chimes in, she doesn't. Now, this court is not bound by Sparkle's order, and with all due respect, the court disagrees with the conclusions in that order entirely. For example, with respect to the Social Security Act, even though this section of U.S. Code seemingly precludes the Social Security Administration from disclosing socials to anyone, that law does not preclude social from doing so in the immigration context because socials can provide information about citizenship. And 8 U.S. Code, this section, expressly says they can. Says that notwithstanding any other provision of federal law, a federal entity is not in any way restricted from sending to other people information about citizenship status, about the lawfulness of an individual. He says she may not have read that. Now, this court does not fault Sparkle for not deferring to our implicit determination that this all was lawful because she's not bound by our ruling any more than this court is bound by hers. Now, this court has similarly rejected an agency's reliance on another consent judgment as an excuse for not complying with the law as this court interpreted it. But that said, it is unfortunate that the parties to this case did not bring Suki's case to this court's attention before it approved the settlement agreement, or the parties to the Suki case did not bring this court's order to her sooner than they did. Now we have a conundrum that exists that might have been avoided if we would have organized and worked together on this, but we haven't done that. But anyways, with respect to the Privacy Act, also, this was one of the basis of Sparky's cases, the modification to the SAFE system plainly falls within the Act's routine use exception. Under this provision, using the socials to verify the identity of potential non-citizens is not incompatible with the purpose of the citizenship at all. And it's undisputed that Homeland published notice of all of this in advance of approving the settlement agreement. They followed the law. And we didn't overlook any of Suki's discussions in her decision relating to Section 1373. But that discussion was not persuasive. She was focused more on the perceived purpose of the statute rather than its plain language. The language explicitly overrides other laws that would have otherwise prohibited this. So once again, Sparkle wants to talk about, well, it's a perceived purpose according to her, and her perception is marred by her dual citizenship status and her emergence into American governance from Trinidad. He says, here in America, we read the plain language, and it says, this overrides other provisions. And moreover, although it is not argued by the parties, it would seem that the court's approval of the settlement agreement requiring SAFE to integrate with social to allow for full SSN searches implicates the exception and authorizes the disclosure of the records, according to this section of the law. So we're actually more in compliance with the law than Sparky is. The court also did not overlook the argument that the balance of the harms weighs against enforcing the agreement. However, that argument is not persuasive. It only focuses on potential harm to the states or to Homeland in having to comply with two conflicting orders rather than the harm that's actually going to the states. So yeah, Homeland, you might be harmed by this, but the states are actually being harmed. And in this court's view, the interests that the amici were purportedly vindicating in Judge Suki's case are far outweighed by Florida's sovereign interest in ensuring that non-citizens are not on their voter rolls and that unlawfully present aliens are not receiving professional licenses, etc. So let's not forget, in Sparkle's case, it's the League of Women Voters who say if you check citizenship status, it's going to make their job harder. They're going to have to go, educate people about how to vote and make sure that something is going to prohibit them from turning people out to the polls. It's all made up. It's nonsensical, which is why it's hard to even articulate. But he says the state's harm is much more pronounced than the League of Women Voters harm. And finally, the court also did not overlook the argument that the court cannot grant relief to Florida because the agency whose cooperation is necessary for this feature is not a party to this case, but is a party to Suki's case. That argument is not without some merit, but it doesn't persuade us that we should not order Homeland to comply with their obligations, and then they can figure out how to best fulfill those obligations. So sorry, you've got Sparkle who's pulling you in the different direction, but I am enforcing my agreement, turn the system back on. So it is now ordered that the plaintiff's emergency motion to enforce the agreement is granted. The defendants shall immediately comply with the court-approved settlement in this case and turn the system back on. Go flip that switch right now. Bulk upload coming back. Social search features coming back, and do it now. You shall file a status report from this order within 7 days and let me know that the systems are back on. And I also want to know what the heck is going on with Sparkle's case in the DC circuit. Signed by T. Kent Wetherell, born in Florida, America, issuing a hell of a decision, actually reading the law and interpreting it based on the text of the law, not on the perceived intent of the legislative history, as Sparkle is doing. So Sparkle said, oh yeah? Well, how about this? This case is now about creating a centralized database. And she walks us through the history. We know exactly what the history is. She ultimately says, I win and I beat you. And her main arguments are that the act of turning this back on will show greater injury than what Florida is suffering. And let me share with you more about this consent decree. She's not happy. She says, all right, T. Kent, I'm from Trinidad, and you're going to see some toboggan attitude right now. She says, somewhat audaciously, the federal defendants argue that they're being irreparably harmed. But she says, well, you entered your consent decree in the middle of this litigation. She says that you came to terms of this deal while you knew this litigation was pending. And of course, the lawsuit was filed way before this lawsuit was ever filed. And Florida and the DOJ down there entered into this agreement. So she said the consent decree was filed on November 28th, 2 months after the League of Women Voters sued here. And so you should not have entered into the settlement agreement since you knew this case was open, is essentially her argument. Now, she also says that you are now making a mockery of the separation of powers. And this is hilarious. Due process, deeply rooted in Anglo-American jurisprudence. So she's going to tell us about Anglo-American jurisprudence as a dual citizen from Trinidad. All right. Finally, they say that they're being irreparably harmed. And she says, with all due respect, the Florida court, which was no doubt pressed for time, erred in its ways. That court may correct those errors down the road, but they presumed that in resolving this claim, that they could determine the rights of the parties. The court said it found that the modifications were not illegal. And she just says, ultimately, he even admits that he didn't look at it good enough. So when entering these decrees, you're not supposed to go into the precise legal rights, and he didn't look into it. And so this was essentially an advisory opinion. He's not allowed to do that. And she's very unhappy that he blasted her. Now, in the end, the federal government entered into the decree with non-adverse parties, and those third parties didn't even know what they were agreeing to. And my case was also pending, and so you should have deferred to us. It's abundantly clear that this court would have erred if it deferred to them, and so you should have deferred to me. And he should have revisited the settlement agreement. And ultimately, even if the order from Florida stands, any harm to homeland does not justify a stay here. The consent decree binds only homeland, not Social Security, and Social Security is not a party to that action. And so my ruling wins, and I'm going to continue to block the SAVE database. So now the homeland people do not meet their heavy burden. And so she says, I win. So we have a battle of the Trinidad judge and the Florida judge unfolding right in front of us. We'll see what the DOJ does. I'm expecting an appeal on this one. And we'll see if the Supreme Court or the Court of Appeals ultimately step in any way to force one of these people into compliance with the other, either the DC Circuit or the Florida Court of Appeals. Otherwise, this thing may be going up to the Supreme Court very soon. And while all of this is happening, Abe Amadei says, enough of this crap, man. It's time to impeach, quote, Judge Sparkle Suki. Her power grab against Trump cannot be tolerated. Rogue judges like her are destroying the rule of law, while communists are undermining America. We have the right to know that only Americans are voting in elections, and Americans elected Trump to lead, not rogue judges from foreign countries who are behaving as activists for the communists that are cloaked in black robes. So an impeachment document is being drafted. I checked on Congress today. It has not been filed yet, but when it does, we'll be reading it for sure. And that's the judge who says you can't validate citizenship. And if you did, maybe you'd learn she's a dual citizen. So you don't want that to happen. Saying this decision also that just came down from T. Kent, Chad extraordinaire out of Florida, says he rejected her legal analysis. He says the SAVE system is perfectly lawful. Nothing violates federal law. She was just digging into the dumpster to find a justification for doing this, saying that Americans deserve free and fair elections, and Sparkle had no right to block Trump. But this is what they do. It's tyranny by the judiciary. And our weak Congress, really aside from guys like Abe Amadei from Arizona, are too weak to do anything about it. And of course, impeachment is very unlikely to result in removal. But you start getting them impeached in the House of Representatives and you leave the rest up to the Senate, that will start, I think, concerning the Supreme Court. Then the Supreme Court can step in to protect the legitimacy of the judiciary, which right now, they're not all that interested in. So he was also on with Garrett Lewis. Here's what he had to say about Sparky over there in D.C.
Can this happen, Congressman? Can you really? Is there enough oomph behind? Tell me the plan, what it takes to impeach a nutjob judge like this.
So I'm planning on introducing articles of impeachment on Thursday, Garrett. And no, I'm aware of the difficulties of it actually impeaching her because, just look at the Save America Act in the Senate. They can't even get that passed. So you think that they can get 2/3 to remove a sitting judge? No. But what the idea is and what's happening is we are constantly shifting the Overton window about not tolerating these communist ideas and these communists on our federal bench. So Judge Sparkle Sukerman, her ruling last month, I'm glad it was just now there's a competing ruling in another district court in Florida. So it's going to have to be taken up to the Court of Appeals. But her ruling basically said the federal government cannot use the Social Security Administration's search and bulk feature that DHS has to stop doing that. Can you imagine, for privacy concerns, can you imagine this? I mean, this is the United States federal government who's in charge of all Social Security numbers, right? That's how you get your Social Security, through the federal government. But they are not able to use that to ensure that only Americans are on voter rolls. You're using the systems that they already have in place. So this judge, I mean, she is warping the law to fit her political ideology.
Yep.
And that is impeachable. I believe it's impeachable because when you are a judge, you take that oath of office to uphold and defend the Constitution of the United States. This judge was, she's foreign born in Trinidad and Tobago. She's an immigrant, which I have no problem with. My problem is if you're going to be an immigrant and you're going to, achieve success by being on the U.S. District Court for the District of Columbia, you follow the law. You actually, honor your oath that you take.
Yeah, and if you are an immigrant and you come into America and then lecture us about our Constitution and about how everything works here and you just got here, that's pretty rude. We don't really appreciate that, especially when you maintain your dual citizenship with your home country. Go be a judge down there. Don't sneak on in here and then get appointed by a brain dead president and then suddenly usurp the will of the people who elected the president to actually run Homeland and to actually pass new reforms to fix these problems. You just act as a judge and then engage in tyranny to strip away the will of the people right out from under us. We don't appreciate that at all, which is why we should have a natural born citizenship requirement for all federal judges across the board. Now, another judge just escaped scrutiny. And this is the type of perversion that happens in the judiciary when they protect themselves and everybody looks the other way. You saw the headline, the backdoor Doogie out of Wisconsin avoids prison time. Isn't that something? Many of us predicted that because judges look out for other judges. Just like when a police officer pulls over another officer for speeding, it's usually just a little, hey, slow down, see you at work tomorrow. But here, backdoor Doogie had another federal judge called Lynn Adelman, who sentenced her today to a $5,000 fine and said she has committed a lifetime of service. Nothing warranting prison. And the way this went down was ridiculous, as we all suspect. Backdoor Doogie gets a $5,000 fine. Prison not necessary. The judge is quoted as saying, for several reasons, prison is not necessary to satisfy the statutory purposes for sentencing. He said Doogie did not appear to have correctional treatment needs and pointed to what he described as a lifetime of service to others, especially illegals using her back door, especially people who are vulnerable or in need. He said, this is a person who has done a lot of good for our community. Yeah. Adelman said the Supreme Court requires judges to consider each people as an individual. The punishment should fit the offender, not merely the crime, saying she was a defendant who made a bad decision in the moment. That's a pretty standard excuse across the board. I represented many defendants. 90% of them made a bad decision in the moment. One, and they don't get any less penalties for that. And she knew exactly what she was doing. Her conduct amounted to a few minutes of conduct. So that's a sentencing mitigation strategy now. The judge said probation also not necessary. So she's not even on probation. Dugan had no apparent need for supervision to deter future violations because she's not a judge anymore, which is maybe the silver lining. He imposed a $5,000 fine. She didn't care. She's going to be a superstar. She'll write a book about the whole thing. She'll go on the TV cables. This is political retribution. My acts that day were consistent. And by the way, she said she had judicial immunity. She fought this. She took no responsibility for this at all. My act that day were consistent with the expressed administrative and community concerns. My judicial acts were not done with any malicious intent. Yeah, imagine if you're a criminal defense lawyer and your client gets sentenced to prison. He's going to be remanded into custody at that time. You're in court, lose the trial. okay, convicted. He's going to be remanded into custody. And you say, Judge, my client's going to vomit. Can I go to the restroom with him? And like, just, we'll be right back. We swear. That would never happen, by the way. They would never let you out of their sight. The bailiff would be right there with you. And you just vomit right here in the trash can. Crap your pants right here. We don't care. But if you're an illegal alien and you're a judge and you're in this criminal defense hypothetical, you take this person outside and then you escape them out of the building and let your convicted felon go free. You're going to jail. You're losing your law license. Your life is basically over because you're going to be charged with helping a prisoner escape. Okay. But if you're a federal judge and there's a federal warrant for an illegal alien in your courtroom, she's actually a state judge, not a federal judge, then you're allowed to escape him. You're allowed to help a wanted person escape out the building. And she says, I've been cast as a scofflaw and a hero. I'm neither. You are a scofflaw. I am a public servant who is just trying to do my job, violating federal law. So again, the whole thing, like the whole system is just completely rigged. It's wild. For 9 years, I've strived to do my best. Defense attorneys asked the court for time served. Prosecutors asked for, I think, 12 to 15, if I remember correctly. But she'll forever be known here, in the very least, if there's any silver lining to this, as the backdoor judge who let an illegal alien named Eduardo use and abuse her backdoor, have his way with it, just go in and out of it as necessary. She enabled it. And backdoor Doogie will forever be ensconced as the backdoor judge, no matter what happens. And she'll have to live with that. So we'll never forget it. The DOJ has 14 days to appeal. We'll see if they do. It's judges looking out for other judges and the judiciary protecting itself to make sure that judicial privilege is extended. And again, there's multiple systems of justice out there. This illegal alien got the benefit of a state level judge to help him escape. Would never, ever happen for an American citizen, ever. She would never do that for you or for me. If federal agents were there saying, how we want you, we're taking you into federal custody, you think this judge would let you out her back door? No way. Because you're a citizen. She only lets illegal aliens use her back door and have their way with it. So we're going to continue to make sure that that label is ensconced and encoded into the history books. Backdoor Doogie escapes this one, but she's still going to be backdoor Dugan. So we'll, of course, keep our eye on these judges, the great battle between T. Kent, the American hero, and Sparky Suki, the Trinidad dual citizen. We'll see what the Court of Appeals does. We'll see if the DOJ appeals the backdoor judge. And of course, want and demand integrity of all of our systems, including elections and more. So we'll keep our eye on this one, my friends. Thank you for joining and subscribing as we do. All right. If you're just getting here, it's a beautiful day. Thank you for joining us. We had a great stream today. Lots of good news breaking. We had Jack Smith now busted. Him and his team allegedly mishandled classified documents during the very moment that they were prosecuting President Trump for classified documents. We got the internal messages from all of Jack's team, who was an illegitimate prosecutor and is not a real boy, despite his media rounds trying to rehabilitate his image. He seems a little bit nervous, and hopefully they're all indicted. We also then turned our attention to the DOJ's warning, now saying, if you don't comply with federal law, we're going to prosecute you for crimes. You're in violation of multiple statutes, and you'll go to jail for it. So don't conspire to help non-citizens vote. Pretty simple. Harmeet sent a letter over, very clear as day. We got another video from her. We saw Adrian Fontes went to go stuff his face with some pies out at Rock Springs Cafe in Arizona off the I-17. I highly recommend it, by the way. Food's pretty good, but the pies are good. In fact, when I used to go to court up in northern Arizona, when I'd go up to like Flagstaff, Arizona to help the NAU kids, I would drive back down, and everybody really from our office would do this. If you were driving down the I-17, you'd stop by Rock Springs Cafe, pick up pies for the whole office. It was a lot of fun. So he might be doing that, but he made a video. He seems very nervous out there. And then we saw the DOJ is appealing the list fight to the full panel on the Sixth Circuit, read through that decision as well. It's clear as day. They have a right to go get these lists, but the lower judges are blocking any enforcement. 1/3 of the states have complied with the request, but the other 2/3 are not. More from Harmeet. JD says, maybe they should just stop cheating and then we could all move on. It would be nice to move on, talk about some other things. But the cheaters must be defeated before we do that. We also saw that there's a battle between the two judges. Pick your fighter, Sparky Suki from Trinidad or the American Chad, T. Kent Weatherwell, the second from Daytona Beach, Florida. And he obliterated her. Then she responded. And you can kind of see his order was 10 pages. Then Sparky had to come out and write 23 pages because she has to explain herself and be very thorough. That shows you that she's big, big mad. We saw that she is now going to be facing impeachment resolutions courtesy of Abe Amadei from Arizona. He also hit the media, explained, I know it's a long shot, but we got to anchor this in. And then the backdoor judge, Dugan, now escaping liability. And that was the day. And so we had a great stream. Thank you for joining us on the afternoon. Of course, we'll be back tomorrow as well. And so thank you for subscribing and making sure we see you back here. But now, my friends, it is time to hear from you. Let's see what you say about all of this and more. I saw some great comments and some super chats. Thank you for sending those in, supporting all of our work here. Very nice things. Hey, Viva sent us a raid, man. Shout out to Viva. We got some new membos as well. This morning, we had a great members only stream. So we also go live for our membos on the weekdays in the mornings. And we're pretty consistent. Sometimes we miss if we've got some other scheduled events, but we had a great one this morning. And what the heck did we talk about this morning? Oh, yeah, it was a good one. Monumental victory in Arizona. So we've been covering the battle between the Arizona Maricopa County Recorder, Justin Heap, and the Maricopa County Board of Supervisors. Huge victory out of the Arizona Supreme Court on that election case, which was a really fun one. We also talked about, the Fulton County judge blocked a subpoena. A federal judge blocked a subpoena out of Fulton County. And we talked about the Charlie Kirk, Tyler Robinson case and went through a bunch of theories and theses about what is going on in that case. And so we talked about all that this morning. Thank you for joining us as a membo, and we'll be back tomorrow morning with even more. Now, let's hear from you. Hey, Jack in the Box is back. There he is. Jack in the Box, get back into the box and go straight to jail. Hey, Bonnie Sawyer. What's up, Bonnie? Thank you for signing up and becoming a supporter. Grab the members only stream from this morning. If you're looking for some other good news, we had a good news one today. Some bad news, some good news today. Fulton County and Georgia, bad news. Arizona, Supreme Court, really good news. And we had fun with that one. Hey, and thank you for signing up here, Bonnie. What's up, Tim Jake, bringing in 5 new friends. Thank you, Tim, for doing this. Amazing to have you. Bringing in Ash BK. What's up, Roderick Kook? We got Jason Deepin Brook is here. Wayne E.O. We've got the Curious Contrarian all in the house, brought in here by Tim Jake. There are some who call him Tim in this little gif right here. Tim. Love it. Hey, see the veil. Blanche is being sued by Katie Fang. I think I saw that, right? That's the Epstein case. I think a journalist is suing Todd Blanche for the Epstein stuff. We haven't really covered Katie Fang because she's so obnoxious. Object Class Keeter. Hey, as docs come out, it shows that even Jack Smith knew he wasn't a real boy. He knew it wasn't. Yeah, and you know, our friend Elliot, Docmaster Elliot, sent me some good documents. I should have incorporated those today. But those, I think, deserve their own segment. He did a FOIA, and he got some good documents. So I think we'll come back on that. Thank you, Elliot. Hey, why isn't Garland and Smith, or Garland and Smith, brought back repeatedly after we find out stuff like this? Honestly, we got to ask Congress. Like, isn't there a weaponization committee? The hell are they doing? We know what they're doing. Nothing. They should form their own incarnations of the J6 committee. They should form a weaponization committee and have hearings just as extensive as the J6ers. And they can just fake the whole thing. Remember, they passed HR 503 to create the J6 committee. And it was illegally constituted from the very beginning. They did not have 5 Republican members. They did not have a minority chair. So just appoint anyone you want. Start your committee. It's the Liz Cheney precedent. Just do whatever you want and start subpoenaing people, haul them in. The courts said back then that there was no right to sue. Those are all internal mechanisms, so you can't sue to stop that from happening, even if they're unconstitutional. Nothing you can do. So they should just do it. And it's the Nancy Pelosi precedent. But exactly right. Haul them in. A weaponization committee. We need an election committee. We need an immigration committee. Haul in Mayorkas. Haul in a COVID committee. But instead, they're just not doing anything. This is why I get so mad about Congress. And I know there's some good people in there, but I really just can't stand what is happening. Because if we lose the House, all that's gone. And we've squandered a lot of effort. I know they're on break. I don't care. Get back here. They can take a break after the midterms. I don't care. I don't care what their break is. I don't care at all. Not even a little bit. Cry harder. Oh, I need time off to go back to... Okay, you can do that after the midterms. Or do that in the month before the midterms. This is the time. And you've been sleeping on your booties up until this moment. So now it's overtime. Is how I would run the House. Can I be speaker? Do you have to actually run for office? Do you have to win? Hey, Jeffrey Adams, isn't that a Brady violation? Yeah, it could be. Yeah, exactly right. So I think you're talking about the Jack Smith. Like if evidence was perverted, if the chain of custody is no longer valid, you can't confirm that evidence was not tampered with, then you need to disclose that to the defense to explain that, hey, we had this problem. You need to know about it. Just like I mentioned about like a DUI vial. What happens if you leave open the crime lab, somebody comes in there and drops alcohol in your DUI blood sample? You can't show that they did. You can't show that they didn't. So the validity of that sample, the integrity is perverted. You're going to win a motion to dismiss on something like that. So Jeffrey Adams, I think that's right. They should have disclosed it. They didn't, which Trump's cases are already dismissed. So they've already failed on that one. But maybe that is evidence of, intent of a crime. Hey, Slimmer, what's up? Slimmer Stubby's joining us. Jack claiming he did everything right with all the information already out shows otherwise is just more proof that he was never qualified for that position. Well, he was qualified in the sense that he was a political partisan hack, which is why they didn't want to go actually get a U.S. attorney in order to do that job. They just brought him over from Europe and said, you're our guy. So he was qualified in that he would do anything, including governing an office, the special counsel's office, as an illegitimate, not a real boy. He played his role perfectly. And now he's going to go out and whine on the cables and say, now I'm under attack. He was the main chief architect of the attack on the president. Now he's under attack for violating his office, misappropriating money, operating without any lawful authority at all, and failing. He was also terrible. Like he's an idiot. They sucked. They couldn't, their prosecutions were also floundering. They didn't consider immunity. That came back down. They had to go revise their indictments. They were just terrible. Rick D, backdoor Doogie sentenced to 0 jail time and $5,000 fine. Man, thank you, Rick. We squeezed that one in there at the end. Yep. Judges protecting judges. And hey, we got baby G emojis coming. That's hilarious. We got the final baby G emojis uploaded to YouTube. They're really hard to make out, but here is a lot of important detail, especially on baby boy Robert. Oh man, look at the size of that baby's guns, man. Heck yeah. Biceps for days. That's just Rhonda, our purveyor of fine emojis, adding some new baby emojis into the chat, man. We love it. Shout out to these new babies. We got a little bicep baby. You know that's going to happen. As soon, if it comes out, it's a boy, man. We're getting little baby dumbbells. Going to be lifting weights from day one. Kid's going to be jacked, baby. Thank you, Sassy Gemini. Hilarious. So those are also added. Amazing. So check out our new emojis, friends. Thank you, Sassy Gemini, a.k.a. Just Rhonda, for doing those. Hey, Just John Doe. In the MS Now clip, Jack Smith literally said, I'm real focused on the people I work with, looking out for them. Yeah, because they're the ones who left the skiff door open. Oops. That's the problem that happens when Dems get in positions of power. Well, they all circle the wagons to protect themselves, just like the judge did with backdoor Doogie. One federal judge protects another state judge. People inside the DOJ will prevent Jack Smith from being charged. I know it's a Trump DOJ, but it's still riddled with moles and bad actors inside. So they all protect themselves. Comey even said at the FBI, hang tight, don't leave. We'll be back soon, and then you can do whatever you want again. Just John, hey, special counsels are appointed precisely in situations involving potential conflicts or extraordinary circumstances where regular DOJ processes might lack sufficient independence or public confidence. You're exactly right. And just John Doe, Jack Smith was never an independent counsel. He inherited the FBI's case. They were already working on this from inside the DOJ. He just came in, faked like he was independent. Everybody called him independent. He never was. He wasn't even a real boy, illegitimately appointed. So he just inherited Arctic Frost and these other case files, pretended like he came to these conclusions on his own. They were all orchestrated and organized by Joe Biden and Merrick Garland and really Lisa Monaco. And he just like walked in, got the boxes full of files and then called it like an independent investigation. And he came to these charges on his own. And he's not organized or orchestrated by anybody. So the whole thing was a sham. And the media kept coming around independent special counsel, and more. Yeah, I saw some of this from the Rubos, quoting a reporter. Yeah, Trump, this made me nervous earlier today. He was talking a lot about the Iranians coming after him. Like 3 times today, he like brought it up. I'm like, what the hell's going on? And then he said that I think he was flying in the old Air Force One. So they were going to bring out the old Air Force One. He was going to get on that one and then take that to England and like hang out with the troops at a base or something and not ride the new Qatari airplane. It was weird. I'm like, okay. So prayers up for the president's safety tonight because there's some weird stuff going on back there. And I think he even made a True Social post about it. Thank you, Rubos. Best salt you've ever had at rubossaltshop.com. Hey, Biology always wins. Thank you, Biology. What's going on? Thank you for bringing in 5 new membos, including Navy Styles, Richard Jack, One Jump Bob, what's up, Aerotech, and John Mole in the house, brought in courtesy of Biology always wins. Welcome aboard, new friends. Thank you, Biology, for bringing in some new membos. We'll see everybody in the morning. Hey, that's Minecraft. Sweet. Hey, Stephen Frazier. Stephen, thank you for bringing in some new membos too, man. Good to see you. Thank you for being a membo yourself. We got Dave is coming in. Tony Goodman. What's up, Boiler Operator? Pero Creations. And Maddie C. Gifted membos, courtesy of our friend Stephen Frazier in the house. Thank you, Stephen. Hopefully your week is going well. Hopefully we see everybody tomorrow. And thank you to Stephen for bringing you in. One old guy, Sparkle Sukanan, needs to be impeached. What a DEI fool. Well, Abe Amaday, man, you're ahead of the class there, one old guy. He said that we're introducing a resolution to do exactly that. Hopefully Congress joins him on that effort. And that's just one place to start. There's many other judges that need to be checked back in line. This old guy, hey, thank you, this old guy. Sparkle should be held personally liable for damages to the system caused by her feature modifications. I'm thinking on the order of $10 million. Yeah, I mean, if Florida can't validate and follow state law, there will absolutely be financial harms related to this decision. She should be liable for these decisions. And she won't be. Nothing will happen to her. Supreme Court won't do anything. Congress won't do anything. So she can continue to wreck the judiciary, and there are no repercussions for her at all, which is why they do it. It's a big problem, my friends. Like the whole system is being perverted by these judges. She's not even American. She's Trinidadian. Maybe you could say she's half American, but she's got her dual citizenship still. So we count that. Rick D, how much would you want to be when they turn it back on? Sparkle will cite them with contempt for not following her order. How much you want to bet? I think. Yeah. Yeah, I don't know what the DOJ is going to do. And by the way, her order is for the whole nation. So what if they just kept it off in DC? Okay, you're a DC judge. This is your jurisdiction. We're going to turn it on for Florida and everyone else, but you cannot make orders that impact the entire nation. And kind of split it. And we'll see what they do. This is going to be a fun one to watch because they're duking it out. You don't hear this often, but there's a major split here. Hey, Biltong is here. What's going on? King of Biltong. You can go to biltongusa.com. You can use code Robert. You'll save 10% off of your dried sausage made with clean ingredients and serious protein. Perfect for snacks, work, trips, and more. biltongusa.com. Code Robert. What's going on? Viva. Hey, thanks for the raid, our friend Viva. We appreciate our friend Viva. He's an amazing dude. Thank you, Viva, for the raid. Shout out to our friends from Viva. Hey, HWIH, man, thank you for the raid. 2 raids over from Rumble. What a glorious day it is. Shout out to all of our Rumble friends joining us. Hopefully stick around. Thank you, Viva and HW. What's up, Curtis Bartle? 48 months as a membo. Man, that's 4 years. Thank you for being here, Curtis, for 4 years, man. Happy anniversary to us. The commies lost and they're angry. Go MAGA. 100%. But I think the commies are, they're still marching forward. Like the game's not over. So we have to stay vigilant and we will. Paul, what's up, Paul? Paul NH, man, thank you for the dono. No comment there, but we appreciate your sending us some love in today. You rock. Psychological projectionist. Hey, perhaps consider the sum of harm to 330 million before you consider the harm to the amici. Before you look at the League of Women Voters and say their rights are more superior and higher priority than the Floridians, the entire state of Florida. How about you just go through that analysis? But she doesn't because she wants an outcome and she engineers it. Hey, Lone Wolf Fan Club, man. Man, thank you for all the raids over on Rumble. We appreciate everybody joining us. Lone Wolf Fan Club in the house. Thank you, Lone Wolf, for sending them over. Hey, and Sandy, Judge Sparkle and Shine, like it, love it. Judge Sparkle and Shine didn't give an injunction. She ordered them to remove the access to the SAVE system. Homeland did that, so they have complied. Then Florida said, give them back access. Homeland can comply with both by now restoring access. Both complied with. So saying, okay, we did remove it. So like the initial removal satisfies it. Okay, so we did the thing. Then we undid the thing. So we just turned it off. You are satisfied. Now we turned it back on. Florida's satisfied. And there is no continuing need to comply with Sparkle and Shine. Who is like a kitchen floor cleaner judge, which is about accurate. Thank you, Sandy. Paul NH. I had a clearance for 25 years. Plus, when they didn't prosecute Hillary, I found something else to do besides electrical engineering and gave up my clearance. When they didn't prosecute, because you were just so mad, like you were just like, this whole system is a total sham. Yeah. Paul NH, man, thank you for being here and for the details on your clearance. Yeah, it's, the classified stuff is critical. But if Trump does something that they don't like, prosecuted. Otherwise, if they do it, you can have a whole server that just violates all the rules. You get away with everything. Thank you, Paul. Hey, this old guy. Okay, so let me get this straight. If you make a bad momentary decision to shoot and kill someone, and if you do it within a very brief period of time, you're clear, you get probation. Yeah, no, it was just a very momentary. I was only stabbing that person for like 2 minutes. That's it. Otherwise, I'm a good person. But I was just stabbing them repeatedly because I was very upset about something that Trump did. And so that's justification to let the person go. She gets judicial privilege and illegal alien privilege. And the judge who sentenced her, of course, I think was a Clinton judge. Clearly. So thank you, this old guy. It's exactly right. You try that. You try to escape somebody who's a wanted felon or a wanted criminal. See what happens to you. You go to jail. Object class Keter. I hope the next one is accepting for department. I hope the next one is after accepting for department. Man, thank you, Object Class Keeter. You're amazing. 34 months as a membo. Thanks for sticking with us for so long. And Rob, what's up, Rob? What about the attorney who represented Eduardo? Well, I don't think she got charged with anything. Yeah, the defense lawyer, who was also, in my opinion, complicit with what was going on. She's like, oh, the judge told us to do it. She was just following the judge's orders. But maybe there should be a bar complaint or something. Like, she knew what she was doing. And they violated the victim's rights in that courtroom. Like, the judge doesn't understand this. Like, it wasn't just the escaping of the illegal alien and letting him use and abuse her back door. It was victims in the courtroom that the illegal alien allegedly beat were seated there. They didn't get their justice. They did not get the actual benefit of the system and the prosecution. The state prosecutor was also violated. He had no say. They just continued the court case and allowed him to appear virtually. So it's even worse than just the escape. She abused her office in order to facilitate a better outcome for a favored class, in this case, an illegal alien, not a citizen. Thank you, Rob. Rick D. Hey, Rob, don't know if you saw it, but Danny Ann was sworn in at the DOJ today. I did not see that, but I'm pretty sure I follow her on X. I'm pretty sure about that. What's she doing over there? Man, hopefully getting down to business. Hey, biology, almost time, Rob. I know. Has Mrs. G started Braxton Hicks yet? No, not yet. But it's July 8th. And she's saying the baby's coming on July 20th. So clock is ticking, man. Biology. Your boy's perfectly ready. I'm going to have a catcher's mitt. Going to catch that puppy coming right out of there, that little creature. Looking forward to it. Thank you, biology. And Rick D. No, you are not required to be an elected member of the House. Exactly. So put me in. All the Constitution says is the Speaker is elected by the members of the House. There is no requirement they be a sitting member. All right, so call your congressman and tell him to vote for me. I'm going to fix this whole friggin' House in no time. Mike Johnson, yeah. Just step aside. We're going to take this we're going to take care of business right now. Thank you, Rick D, for confirming. I vote for myself for Speaker of the House. Sharpie Guy, hey, please find my comment that goes along with the tip. Says, OMG, Rob, I'm actually ill listening to Doogie's sentence. Pathetic. The judiciary is so corrupt and the Republicans, pubs got played on judges. Remember that? I'm struggling with it all. How do we handle it going forward, Rob? Well, we use the corruption and the disgustingness as fuel and energy, and it just charges us. And we fight even harder, baby. That's what we do. We're not going to get deflated and just bail out and say, okay, I guess the communists win. America's over. Game over. Not going to happen. So, Sharpie Guy, we're going to keep on keeping on here, my man. And we have to keep calling him out. And remember, she shall henceforth be forever known as the backdoor judge. Backdoor Dugan. Forever. Maybe we'll make a plaque. Hey, Sandy, Sparkle and Shine issued a vacatur, not an injunction. So I think your argument is that it's not permanent. It's not a permanent injunction. I'd have to go back and check. I'll take your word for it, but I guarantee you if they turn it back on, she's going to say you're in violation of my order, whatever it happens to be. So the DOJ can kind of, try to get clever about it, but she's going to say you're in violation of my order, issue a contempt ruling. But I understand your point. Maybe they'll say we are complying. We complied under the law with exactly what you handed down. Thank you, Sandy. And hey, Jim Tells You, we'll do a raid on our friend Jim Tells You. Amazing, Jim. Hopefully you have a great stream over there. And friends, thanks for checking out his channel. Let's see what else is happening. We'll take some final comments and then we'll wrap on the night. And here we go. The Veil. What are the chances that the FBI personnel who raided Trump's wife's Melania's underwear drawer might actually be a crossdresser? Well, they are the FBI. So chances that the FBI who raided Melania's underwear drawers are crossdressers, 98%, if I had to guess. At least, might be higher. Elliot, the double Dutch oaths of Jack Smith. Hey, all right, so check this one out. I think this came from Elliot's documents that I mentioned, and I was negligent to fail to include today. But check that link out, philippicks.substack.com. The double Dutch oaths of Jack. Elliot's been on this for years, filed a FOIA request, got some good data back, and sent it over and gave us permission to cover it because he's the doc master. So thank you, Elliot, for that. Check that one out. AZ Soccer Opa. Another reason that Fontes would be nervous is Heap's recent success. We talked about that today. Remember that Heap identified out of 61,000 voters, 400 illegal, and 200 of those had actually voted. Yeah, that's right. Yeah, Adrian has a different tune today. I don't do anything. I'm not responsible for anything. All I'm good for is eating pie. Leave me alone. Don't prosecute me or give us some money. And why don't you work with us? But I know you're trying to work with us, and I threaten everybody with crimes, and now you're threatening me with crimes. So be nice. Yeah. Hey, The Veil, asking about McConnell. We made a video about that. And apparently, I think the governor of Kentucky sent him a letter. So no, they can't, the senator is the senator. If like he's on life support, we should know that. And the staffers really shouldn't just be making decisions on behalf of the senator because they are not the senator. Yeah, when are they no longer capable of doing their job? Yeah, we're about to find out. There were a bunch of weird posts last night. Everybody was like making fun of them because people were saying, I just got off the phone with Mitch McConnell and he said he's great. In fact, he's doing backflips there in the hospital. And he just finished 3 crossword puzzles and drafted some new legislation, and he gave us guidance on judges. You're like, okay, really? He's doing well. We talked to him for 45 minutes. Okay. Then other people were like, hey, I just got off the phone with Mitch McConnell, and he said that he loves the SAVE Act or something. Kind of like, obviously they didn't talk to him, but yeah, I don't know what's going on there, but I think I saw that the governor of Kentucky sent a letter saying, hey, what's the status of this dude? Yeah, memes were flying. It was hilarious last night. Just got off the phone with Mitch McConnell, and he said baby back ribs are the best thing ever. What? Okay, maybe. Hey, The Veil says the speaker does not require to be a sitting member. That's what I thought. That's why I suggested it, man. Hell yeah. So I have a chance. So Rand Paul said we should elect Elon Musk. It should be good. It would be good. I think Elon can clean things up. But you need somebody in there who's just like, will literally go door to door and put other members in headlocks. I can do that. I know how to do arm bars and triangles, triangle chokes. So, and I think you're allowed to do that because you have congressional immunity. You have legislative immunity. So you can literally just go beat everybody, and just say, I'm immune. What are you going to do about it? Now, there's some bigger dudes than me in there, some, ex-military and stuff like that. So I got to figure that one out. But I can figure it out. I'll work on it. Peacefully and patriotically within the confines of the law with legislative immunity, just headlock everybody. Just take care of business, Somebody's got to do it, man. I'm willing to do it for America. And what are they going to do about it? I've got immunity. I can do whatever I want. I'm in Congress. I'm the Speaker of the House. What are you going to do? So, yeah, you know what I'm saying? Like, that's the type of energy that we need. I've got it, baby. So put me in. Call your representatives. Say, Rob's going to come headlock you. So vote for him. Maybe that'll work. So anyways, friends, we'll leave it there. We'll have a beautiful evening, and then we'll come back tomorrow and get into it again. Hey, I'm P-Pickin' Q. What's going on? I can't take it anymore. Yes, you can. You can take it, and you will. And we're going to continue on right here. Ever since it's been hinted that Trump might use the emergency EO and ballots started being seized, the Democrats are losing their minds. Do you have any Democrat friends? No. Got rid of them, basically, when we started the show. I'm so tired of hearing 60 cases, no evidence. Even Trump judges said no evidence, always using the Trump R statement like some kind of holy grail. Then they throw up the Mr. Haas, ha-has, over and over. I try to get through their TDS brains. They were all dismissed. Quote. Yeah, well, you can just look up those cases. Ask them, for example, how many of those cases went to substantive discovery? Answer 0. A couple of them had merits hearings. Like, look them up. Ask them to explain the number. Where'd that number come from? How many of those cases went to trial? Do you know? 0. How many of those cases were voluntarily dismissed after election deadlines came and passed? About a third of them. So Yeah, they weren't. You just said it. Most of them were never adjudicated. Only 3 of them had really any substance to them, and they were just small sample sizes. So it's just really a sign of their ignorance and how idiotic they are. That they just regurgitate a number, ask them to explain the number. Well, Trump judges said it too. Are you familiar with issues of standing? Do you know what the phrase justiciability means? Do you know things like ripeness and estoppel and latches? Are you familiar with the process at all? And they don't, in my experience. I've been asked that same question a lot, and I just explain it to them. And they say, oh, that makes sense. And then you say, the people who are doing use the Georgia example to respond. The people doing the investigations were then appointed to become the judges, and the judges then inherited the prosecutions that they were supposed to investigate. Vic Reynolds in Georgia became a Superior Court judge. Scott McAfee became a Superior Court judge. Both of those people were supposed to investigate the Georgia fraud. They didn't. They cut it off. They were made to be the judges. And then McAfee inherited the case that was being prosecuted by Fannie, with whom he worked in her office. So it's one big disgusting incestuous family. And all it does is illuminate their ignorance. And so don't let it get to you. Just say, oh, well, you say you don't know anything about the law. Okay. 60 cases, explain it. Where'd they come from? Where were they? What were the issues? Do you know? Why were they dismissed? What was the basis of the dismissal? Can you explain that? Was it a trial? Did they all get dismissed after a trial because they were found there was no liability there? No, of course not. It's just idiotic. They just watch too much MS now. So, yeah, and they don't care. Honestly, that's exactly right. They really don't care. So in large part, depending on how far gone they are, if their brain is completely eviscerated, it's just not even worth it. Not even worth talking to it. Save your breath, save your energy, go talk to somebody who actually can understand what you're saying. Because these people don't want to learn the truth. It's like COVID. It's like talking to somebody who is COVID brained. They're all COVID brained. Not all of them, but many of them are. You can't reason with them. Totally fried. I remember looking at people talking COVID and their eyes just glaze over like I'm going to kill them. So it just, some are too far gone. Spend your energy on the people who still can be saved and still can understand these things. There are those people. They still actually exist out there. So spend your energy on them. Don't worry about the ultra leftists who have no reasoning capability left at all. But friends, it's been a beautiful day. We'll pause here for the night. We'll come back tomorrow. We'll get into it again. See if we got any comments on X, and then we'll wrap it up on the day. Yeah, what's up, Neuro D, man? Thank you for sharing the channel and our locals community. Shout out to Neuro D, mod extraordinaire in the house. Join us on Locals, watchingthewatchers.locals.com, or on YouTube if you want to become a member. 2 great places to join up. And we're going to have a beautiful morning stream tomorrow on Thursday. It's going to be great. Be torn. Hey, judicial activism and lawfare will end when we get serious about this. And when we high fructose corn syrup them lawfully and legally. Question, how was Lynn Adelman given the position of presiding over the trial of Lynn Dugan? I think that judge was just assigned, randomly. Like, I think that judge was the main judge on the case the entire time, Maiden Theus. And judges are just assigned like on a rotation. So case comes in, random assignment, unless you're Judge Boasberg and you get all of the cases that you want. And then you do what you want with those cases. But yeah, I think it's just a random assignment. As far as we know, I don't think there's anything else uncouth going on, but maybe there is. Maiden, hey, watched every second so far. As usual, Rob, brilliant and thorough. Well, I don't know about brilliant, but thorough for sure. We read a lot of documents here. Thank you, Maiden Theus. We appreciate that. And yeah, CR citizens, states should not be getting any federal money to perform activities that are required of states under the Constitution. Citing the Constitution. And yeah, I think there's a lot of sense to that. If the states want to pay for illegal aliens, then they can pay for them. But federal money should not go to them. It should all be cut off across the board. Yeah, some citizens will be impacted by that, but apparently the state is so flush that they can provide for all of these illegals. So any sanctuary city should be penalized with the power of the purse and more. But thank you, CR. What's up? Hey, tagging Adrian Fontes, who looks very nervous, probably stuffing his face right now with some key lime pie. CV Tra, accountability. Is that one of those made up words that have no meaning? It's seeming that way. Yeah, like racist and others. Hey, great show tonight. Thank you, Maynard. And, oh, another immigration lawyer suspended. Man, we love those cases. Thanks for flagging that one for us. Maine immigration lawyer suspended. Yeah, a lot of fraud in immigration, and the lawyers are behind a lot of it. So good stuff. All right, so thanks for sending those in over on X. I think we're getting a little bit more juice on X now. I think they're making some changes, which is good. And then Thomas Massey had a comment. He said, I just spoke to Mitch McConnell, and yes, this is how you know it's this is how you know. All these memes were flying around. I spoke to McConnell for 20 minutes this morning. He said we should end the war with Iran, quit giving aid to Israel, stop spying on Americans without a warrant, and he's really sorry about how my primary turned out. So there's a lot of that going on last night. It's pretty funny. And he definitely did not say that because he wouldn't say those things. So pretty funny. All right. So, hopefully Mitch is doing cartwheels back there and he's, beep bopping and booping. He's doing the Irish jig back there, just kind of dancing and moving around. But we don't think he is, but we wish him well. Hopefully he recovers and comes back. All right. We'll see. So, all right, friends, it's been a beautiful day and we'll have a lovely evening. We'll get some great sleep and then come back tomorrow and get into it again. It's going to be a lovely Thursday, no doubt about it. And so before we close it out, big thanks to our extraordinary mods and meme smiths. Shout outs to who is joining us today. John in the house. We got Muffin Rando, Donut Mind Me, of course, K Bean in the house, Neuro D, Janek and Dog Digger holding the fort down over on the Rumbles. We got Geegum Geegum, our meme smith extraordinaire, Just Rhonda, our purveyor of fine emojis, and Elliot Docmaster in the house. And my friends, thank you for being here. Thank you for subscribing to our channel. Thank you for sharing the show with a friend or family member so they can come join us on this tremendous, never-ending search for truth. We'll come back tomorrow to get into it again. And in order to do it appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful evening. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we